point is commercial exploitation and regulation, the sports industry. New wine in old skins. I'm Brian Kajubi from Max Advocates. I'm here as your moderator and I'll be taking you through the session till midday. We're joined by Dr. Don Rukare. So we're joined by Dr. Don Rukare, one of our presenters. But briefly, we're going to tackle several topics, and I'll go straight to Don. Don is a bit engaged, he's in transit, but we're delighted to have him on this call. To save time, I'll not go through the rich CV of Doctor, but briefly, is the president of the Uganda Olympic Committee and is a senior lecturer of sports law at Uganda Christian University, a School of Law. Don, to save time, kindly join us and take us through your presentation. I'm acutely aware that soon you'll be off because you're in transit. Doctor?
Thank you very much, Brian. I hope you morning to all of you. So, Brian, can you kindly confirm that you can hear me?
Yes, Doctor, we can hear you very well.
registered and declared a sports association, what you need to do. What does 50% mean? Does it mean you must have officers in at least in these districts, 75% presence? What does it mean? This is a very big gray area, and I predict going forward it's going to cause a lot of issues. What is the scope of commercial rights provided for in the law and regulation is not clear. It seems to stray into the areas of intellectual property and take into account the recent case of Proline versus MTN and Saatchi, where the judge gave extensive intellectual property rights to athletes, which wasn't hitherto the case, is a cause for pause. Registration of agents doesn't seem to take into account the fact that some international federations like FIFA require now people to do the FIFA exam and not the national system. So how, again, the issue of plurality they talked about, how are we taking into account Uganda's obligations that are international in nature that don't seem to be provided for when it comes to the regulatory agents, which seems to be the preserve of national federations under the current law. The question around regulatory overreach, a lot of powers have been given to the minister, including rights of appeal to the minister, which we think is inordinately an overburden to the minister. The fee structure, in fact, many people have argued that when you look at the regulatory framework, the new regulation, the draft regulations, everything is being charged and the fees are quite exorbitant. For example, each federation or association will be required to pay, if the new regulations are passed, 5 million per year for arbitration fees, in addition to other inordinate costs, 2 million, I think, for registration. So it's quite a very excessive fee structure that is being proposed in the new regulations, which I think will cause a bit of operational challenges for our federations. The questions of anti-doping sections in Section 56 are not aligned to WADA. In fact, right now we are hoping to table an amendment already, which has been drafted to ensure that Uganda is compliant with WADA so that we don't fall afoul of possible sanctions. The questions around what community clubs mean is not clear. And this is something that needs to be further defined. So as you can see, there are a number of areas which we in the sports field, and I hope our lawyers on this call can take time to pause. There's also been the question as to whether, taking into account that the new regulations are not in place after a year of coming into force of the new law, whether they're operating legally. There have been some opinions set forth by people like Ivan Ojapol and Brian himself, question the legality of the federations. And Brian, I'd like to have coffee over you. I saw your op-ed, I think, in the Monitor. So there are a number of key challenges that we are facing with the new law, despite it being a welcome initiative. Looking ahead, we'd like to see that the consultations that were held on the draft regulations about 3 weeks ago take into account the various written opinions from federations and the Olympic Committee that were submitted, so that the input and voices from stakeholders are included, and hopefully the regulations are tightened and improved so as to ensure that they actually serve the purpose that they're supposed to do. The regulator, which is National Council of Sports, in my view, should take, because it's now going to be given wide powers. For example, under the new regulations and law, it will be the body that is going to declare sports associations and sports federations, national sports. It will also have the power to incorporate them and give them legal status, as well as register them and deregister them. So these are quite wide-ranging powers. And our view is that the regulator should take more of a mentorship approach rather than a punitive approach, because if it takes the latter, it will really be causing a lot of governance challenges. And we hope there will be a transition period for federation associations in order for them to fully comply. Because there are some sports currently, for example, swimming, where I come from, archery, fencing, which may not be able, under the new regulations and governance framework, to have presence in 50% or 50 districts or 75, because we don't have swimming pools or facilities. Are you going to shut them down? What will happen? So if we can have a transitionary period, maybe of 3 to 5 years, to allow federations to be coached and mentored and supported to put in place facilities, and maybe partnership with schools may be a way forward, because otherwise a lot of the federations and associations as currently configured may not be able to meet the threshold of Section 9 and 10 of the new law and the attendant regulations. So Brian, this was a quick whistle-stop view, in my view, that if I was to conclude, CAP 151 is welcome. It's a very welcome law. We are looking at moving Uganda forward. But the whole idea of what it means to be professional vis-a-vis amateur and how we articulate the actual implementation when the rubber hits the road is going to be something that we watch as sports lawyers and lawyers in general as we go forward. There's an interesting provision, I think, in section 57, which ousts the jurisdiction of courts. Again, that's a very interesting provision, Brian and colleagues. The provision says that sports disputes, including interpretations of our constitutions, should not and cannot be subjected to court intervention, effectively out the jurisdiction of court. I don't know whether this is legal. We have had a lot of debates on this question as to the legality of this particular section. I think it's section 57D, which provides for this exclusion of court jurisdiction. So as you can see, colleagues, the law is welcome. It covers a number of areas, but there are also a number of areas of concern. And I'm hoping that through these kind of engagements, both with lawyers from Uganda and some of our colleagues, Dave from further afield, and I greet him, we'll be able to provide some bit of guidance and hopefully remove the needle of regulatory framework in sports in Uganda forward. So, Brian, thank you very much. And maybe I'll take one or two questions before I have to log off. Thank you, Brian.
Thank you so much, Doctor, for that insightful presentation. Before I let you go, Doctor, maybe our attendees may share their questions later. I have one or two questions. One, from your presentation, I'm quite sure that you are a good preacher of good governance, accountability, among others. Do you think that this act actually answers questions of good governance and accountability in the sports industry? Because we've seen for a number of years, sports federations in general, they're faced with challenges of accountability and good governance. You may cite some examples where you've notably presented your papers in conferences about this. Has this act, CAP 151, answered the questions to do with bad governance or good governance and issues of accountability in the sports industry?
Sorry, Brian, was that a question? I didn't hear that.
Yes, so it was a question to do with accountability and good governance in line to this act. Do you think it answers or it solves challenges around accountability and governance or lack of it in sports
Brian,
industry?
It does. Yes, it does. When it comes to accountability, it requires national federations and associations to be, one, to register with the National Council of Sports. It requires them from a financial perspective to ensure that they file their annual returns, their audited reports, annual reports, sources of financing. That is a requirement under the new law, which was previously also there. So this is now being a requirement. It's going to be seen whether this is actually going to happen. In addition, there are questions around ensuring that national federations and associations have a national character and outreach, in addition to their governance structure in terms of providing, for example, this, having a president in place, secretary general, and also national council has indicated from a governance side that they require federations and associations to have nowadays preferably members of staff and an office, having a CEO, having an accountant. So there are a number of things that are both within the law and practice, that guidance that we're getting from National Council, that speak to accountability and ensuring that federations and associations are able to provide this info, both money that we receive from government. I think the biggest benefactor of money from government is football. They receive about 17.5 billion of the 47 or 45 billion that is allocated to National Council of Sports. So football, FIFA takes the lion's share. But if you receive public money, you're supposed to account for it. If you receive money from your international federations, some organizations receive money. They also then have to account for this annually by filing these information and returns to National Council of Sports. The practice has been mixed. Some have complied with this in the past. Others have resisted it, saying they only want to comply if they receive public money and they don't have to have the full range. But the argument from NCS is that we receive this money in trust for the public of Uganda, and therefore we have to account. So yes, Brian, these provisions are contained in the National Sports Act, Cap 151.
Thank you, Doctor. One last question, then we let you to travel safely. You've talked about international compliance to do with WADA. In as far as our Act Cap 151 is concerned, it falls short of regulatory compliance, and this refers to international instruments relating to WADA. Other than WADA, the World Anti-Doping Agency, are there other international instruments that require compliance? And this I mean in general, without delving into specific sports. This time you may have football, but there are those international charters, instruments that are universally applicable to different sports. So other than WADA, is there any other international commitment and compliance that is required by Uganda sports industry under this act to comply, and if so, within which deadline?
Yes, Brian, that's a very pertinent question. That's one of the issues that raised, the issue of plurality, and the fact Uganda is part of the wider ecosystem at the regional and international level. Number one, all national federations or associations have to comply with their international federation requirements. So, for example, swimming would have to comply with the World Aquatics, football with the FIFA. So each national body has to comply with the international federation. So we'd have to go on a case by case. For example, on issues of nationality, on issues of doping, on issues of entry requirements. So that is critical. Two, the issue around, as you said, the FIFA regulations, for example, on how you can become an agent have changed. You have to have the FIFA exams. They are twice a year. They no longer just accept. There's the question of manipulation of sport. There's a manipulation code and match fixing. We also have to ensure that we comply with that. The IOC charter, very critical when it comes to now for the first time in the law, they are provided for the the Uganda Olympic Committee. There are some areas that are a bit, let me say, sensitive, because, for example, they say team selection will be the preserve of National Council, and you have to get approval of the minister. This has been argued impinges on the IOC charter, which gives sport autonomy to the National Olympic Committees, in this case, the Uganda Olympic Committee. So there are a number of those issues that are there, the issues around academies, commercial rights. So there are a number of areas where the law does not take into account not only WADA, on what is happening when it comes to compliance. Safeguarding is a very big issue. We also have to be cognizant of are we aligned to the international practice of safeguarding. There are topics, for example, criminalizing match fixing and anti-doping. These things have to be aligned to what is provided for in the relevant international codes. So these are areas, Brian, which we have been advising, and we hope that we should be able to align ourselves as a country to the international requirements, since we are part of this system and not just insulated to Uganda alone.
Thank you, Don. I admire your passion for sports practice and administration. Maybe your parting shots to the lawyers on this call and sports administrators as you take leave. Any tips for the lawyers on this call?
Maybe, Brian, I see a question from Prosi Katongole. She's saying, since resort to court has been ousted, where should sports disputes be filed? Prosi, what the law is providing for now is a list of arbitrators. And as I said in the regulation, they're even saying each federation should pay 5 million for arbitration as a flat fee, and then you pay the cost of the arbitrator. So currently, the regulations and the law envisage that there will be a list of arbitrators that will be put forward by the federations and appointed by the minister every, I think, 2 or so years. So Brian, I believe, will be part of those and our colleagues here. And proceed. This list of arbitrators then will be the ones that will be adjudicating or will be arbitrating rather these cases. So as I said, one of the missed opportunities was we were pushing for a tribunal, like what they have in Kenya, but because of the ongoing rationalization of agencies, as you're aware, there are UNRWA and others, Uganda Forest Authority, Uganda are being merged. The government was reluctant and refused to create a tribunal, saying this would be duplication. We made relevant arguments which were rejected, and I think this was a missed opportunity, as I said earlier. So currently, the idea will be that there will be a list of arbitrators which is yet to be appointed, and if there's any sports dispute, the arbitrators will be appointed by the parties, and the arbitrators will issue an award which seems to be final and not appealable and cannot maybe to CAS, which is the Court of Arbitration for Sports, but we can't for now because of law. But I believe that provision can be challenged, and I know there are some lawyers who are thinking of going in that direction. So I hope, Prosi, that answers your question. And yeah.
Thank you so much, Doctor.
There's one more or two I can take.
Yes. Yes, Doctor, you can take it on.
It seems there's none.
I think there's none, Doctor. All right. Thank you so much for that insightful presentation.
Thank you for following.
And safe flight, Doctor. Reach safely.
Thank you very much.
For those who have just joined us, we are live. So far, we have over 90 participants attending online. I want to thank the Uganda organizing this CLE, a specialized training under sports law. For those who have just joined, the theme is commercial exploitation and regulation in the sports industry. New wine in old skins. Don has given us an in-depth analysis about the new act we have of the National Sports Act for those who have attended. Number two, we are joined by the Vice President of the Uganda Law Society. In a few minutes, he will be joining us to give his opening remarks. We want to thank the Uganda Law Society CLE Committee for putting up this together. Thank you so much. I also want to thank Max Advocates, our conveners today, who have enabled this to happen. And above all the participants and our panelists. We have eminent members and speakers for this session. Please stay online. A lot is going to be unpacked. For those who are wondering, why are we discussing sports law? For clarity, it's never about only sports, football, and all that. I prefer to use sport and the law as opposed to sports law. Of course, sport and the law will definitely give you sports law. There's a lot to practice in this field. Many speakers, previous speakers, have written about this. A gentleman called Ivan Jakol, Don himself. There are quite many. So it's no longer something that is new. I don't want to say that it's a virgin area. No, it's no longer virgin. It's only that probably us practitioners are not well conversant with it. So as you're aware that the sports industry has emerged as a significant contributor to the local economy. So this combines the legal, commercial, and regulatory dimensions in practice, which calls for the legal practitioners or lawyers to participate. Every time you see a law, that is work for a lawyer. Every time there's regulation, that is bread and butter for a lawyer. So in Uganda, the growth of professional sports necessitates a robust legal framework, which calls for compliance, observation of sports rights, and to ensure fair regulation and effective dispute resolution within the sports industry. So the enactment of this National Sports Act presents both opportunities and challenges in the governance of sports, as Dr. Don has elaborated on the same. This requires us, the lawyers, sports administrators, to adapt to these evolving dynamics such that not only do we benefit from the opportunities presented under the Act, but also to advocate for the rights of sports authorities and other personalities. So this CLE training, for those who have just joined us, aims to equip us, the lawyers, legal practitioners, sports administrators in sports federations, regulators, with the necessary knowledge and skills to enable us to navigate the intricate policies and any other areas relating to regulation and commercialization of sports. So through the provoking discussions we're going to have today, I'm very led by different experts. I'm very certain that we shall benefit extensively, and mainly our session is about deepening our understanding in the National Sports Act and its application to the regulation of sports in Uganda. We also want to support athletes through this CLE for those who represent different sports persons. So at the end of this session, we should be able to explore how legal practitioners can better serve athletes during disciplinary and legal disputes. We have speakers who will give us insights on that. We also have a sports lawyer who also happens to be a rugby player who will share with us his experience in the sports disciplinary committees or tribunals, for lack of a better word. Then lastly, as lawyers, we shouldn't only look at the law. Our concern should also be the business of the game. When we talk about sports law, it's not all about the law, regulation, and compliance. We should also be concerned about the business of the law. So here we're going to unlock the commercial value of the game. And this value has been only to a few people. The lawyers we have been always behind the curtains, but we are supposed to be equipped with the tools to advise on and protect our commercial rights in the sports industry so that everyone benefits. So briefly, those are some of the objectives of today's session, the CLE event on sports law. So Doctor has taken us through sports regulation. Our next topic will be by Mr. Dennis Lukambi, but before Dennis, allow me invite the Vice President of Uganda Law Society, Mr. Asimwe, I think is on the call. Vice President,
yes,
you're most welcome.
Yes, Brian, I am.
Over to you for the opening remarks. Thank you.
All right, thank you. I must say, I hope you can hear me. Confirm that you can hear me, Brian.
Yes, we can hear you very well.
All right, thank you very much, Brian. I must say that hearing you speak and Doctor has excited me, and I'm very sure to keep me glued to this conversation. It's really insightful, and I look forward to an exciting engagement. Well, good morning, distinguished guests, colleagues, and participants. It is both an honor and a privilege to welcome you to this continuing legal education session on sports law under the theme commercial exploitation and regulation in the sports industry, new wine in old skins. The sports industry, both global and locally, has evolved into a formidable driver of economic growth and societal impact. In Uganda, particularly, the rise of professional sports has illuminated both immense opportunities and critical challenges, and underscoring the need for a robust legal and regulatory framework to support its growth. The enactment of the National Sports Act alone marked a significant milestone in streamlining governance and fostering accountability in sports. However, like all laws, its true potential lies in how effectively it is understood, implemented, and where necessary, improved. As legal practitioners, we are uniquely positioned to shape this narrative to ensure that the regulatory environment not only protects the integrity of sports, but also unlocks its vast commercial value. As we embark on these discussions, I encourage each of you to actively engage, share your perspectives, and learn from the wealth of experience in this room. Together, we have an opportunity not to only enhance our professional capabilities, but also contribute meaningfully to the development of Uganda's sports sector. In conclusion, I'm confident that today's session will be both enlightening and empowering. Let us seize this moment to ensure that our legal frameworks not only adapt, but also anticipate the evolving dynamics of this vibrant industry. And before I take leave, I'd like to thank all the participants. Thank you, Brian. Thank you, Max Advocate, for convening this session. And also a thank you to the experts we have here who are sharing. They are going to share their knowledge and their vast experience. Thank you, and look forward to an engaging and productive session. Thank you. Over to you, Brian.
Thank you so much, VP, for the opening remarks. And without wasting in a single minute, we shall go straight to our next topic. Our next presenter is Mr. Dennis Lukambi. I hope he's on the call.
Yeah, I am on the call, Brian.
Yes, Dennis, you're most welcome. Dennis is going to take us through the component of commercial rights in sports. Dennis is the head legal at Federation of Uganda Football Association. He's also on the legal committee of FUFA, where I happen to sit with him as well, but also he sits on several sports committees. Dennis contributed extensively to this National Sports Act under the stewardship of the president of FUFA, Honorable Magogo. Though Dennis, many sports lawyers have critiqued and shared their opinions that the National Sports Act appeals more to the game of football than the other sports disciplines. Maybe you share your thoughts on that, but we're more interested in you sharing your insights regarding the key areas in commercial exploitation. That is sponsorship rights, ticketing, broadcasting rights, but also sports merchandising rights. You share with us the examples where your federation or your first client, where they have suffered a lot of counterfeiting. On this call, we are also joined by Mr. Fred Mwema, who is a keen practitioner, and he preaches the gospel of anti-counterfeits. But that is an area lawyers will need to exploit. So members on this call are more interested in knowing how do they benefit, but also help sports athletes, federations, sports clubs in commercial exploitation of their sports products. I'm aware that sport is now a product. It's a commercial product. Through the concept of commodification, it's no longer for fun and luxury. People package this product and you find the entire industry benefiting from this product, which is as a result of commodification. Premier League did it as early as 1992 there. Previously, it was a boring product. They went back on the drawing board. They repackaged the product, sold it back to the consumers, and consumers, whom you call fans, got so obsessed about this product. You will tell us whether, from your sports discipline, whether Uganda we've done our best to do that sports commodification, whether actually this product is being sold back to fans in a special way, in a more packaged way, among others. But the key points of concern around your client, your number one client, How is your client exploiting their sports products? How is your client repackaging those sports products, ranging from ticketing? Recently, we experienced some ugly scenes at Nambole, not once, not twice, relating to ticketing, primary ticketing, ticket toting, black market sales relating to sports tickets. So lawyers have been so much into the legalese, but there is now the business side of it. And at least your client seems to have progressed very well in as far as commodification is concerned and commercialization of its products. Counsel Dennis Lukambi, over to you.
Yeah, thank you, Brian, for that elaboration.
Dennis, kindly unmute.
Okay. Thank you, Brian. Can you hear me now?
So we can hear you.
Okay, I'm going to share a presentation for purposes because this is a very bit technical and fresh in minds of most of the lawyers. It would be better if I could share like 4 or 5 slides for such that I put sponsors, because most of the transactions need to be really displayed on how FUFA and other clients at large is trying to handle the business of sport. My slide, I'll be straight, go out to the presentation. This is a huge topic because you may find that sponsorship alone could cover a full week, but I'll try my level best from experience to try and summarize for the benefit of all our guys on the cluster here and for the benefit of the lawyers. Because as we mentioned, the current radical news trying to enable opportunities to widen our practice such that we don't restrict ourselves on the bail applications and land issues, which is a bit shrinking. We try to widen, and they encouraged us to make sure that our lawyers appreciate, because you know where you need the client able to implement the transaction in a better and in a very effective way. So basically, when you look about, we talk about the introduction, and these are in principle, because media and broadcasting, then merchandise, licensing, tickets, and match day events. This is how sports events, sports federations, sports organizations, and tournaments, huge tournaments, the World Rugby, World Football, Africa Cup of Nations. This is where they equip their money. This is one of the means how they acquire funds from the tournament they organize, because you need to appreciate this is a service that is for the public. Most of the clients to the sports world, they go in there to be entertained. And then these other business packages align with that tournament or a game or a match or whatever sort. This is purely sport. And unless you package your product, whether rugby or a boxing match or tennis, to be able to invite and entice the fans to come who are the core of the game, then you may be doing a disservice. So in principle, we want lawyers also to be part of this agenda. It's not basically having a game. For example, in Uganda here, we have, even in our fraternity, the legal practice, we have the Lawyers League. But you may be shocked that some lawyers may not even be aware that there is what we call a Lawyers League. They are interested in other businesses. In the weekends, they go to their farms. So unless we package the lawyers, be able to invite all the lawyers, because if only you have a match and only maybe 100 lawyers will attend for that match, now that cannot be able to invite sponsorship, because sponsorship comes with numbers. Any sponsor would want to be aligned with a tournament or a game or a league with numbers. it's not even surprising that sometimes you find that some hobbies like secondary schools or universities league sometimes sound more than other particular leagues because of the package and the marketing that it does. So unless before we even go into being part of appreciating how sports acquire its revenue through the media and sponsorship and merchandise and licensing, we need to be part of that journey as lawyers. That's one thing I appreciated. And I wish I knew that I knew this before I even joined the federation, would have been at least in a better place now. So we need to be part of the journey. And how do we be part of the journey? World over, this was, I picked this from the books of accounts of Arsenal, and they are trying to show that match day, broadcast, commercial, entirely even the world of the game. That's why they acquire their money to rule these means. So the best element, if we talk about sport, we can't rule out the element of IP. We are aware if you talk about intellectual property, it's a creation of a mind, something that is innovated, and it is entails of elements, including trademarks and copyright. We don't so much have a lot of trade secrets in sport, but there is an element of industrial design and other service providers like Adidas, Umbro. They benefit from the element of third patents. But as far as this discussion is concerned, we will be aligned more on trademarks and copyright because it helps the tournament, helps the federation, helps the players themselves, the Cristiano Ronaldo's of this world, the Wayne Rooney, to have, we find that their name or their signature, they register them as a trademark. And once it is registered, then you know you can't deal with it without a license or without being authorized. Otherwise, you will be challenged with for infringement of that trademark. And copyright, they are the most common elements of sport that we need to align with the brand to build a brand called sport or a tournament in a particular element. Sport is general, it involves over 100 disciplines. But when you talk about a particular tournament, in this case, if we talk about Africa Cup of Nations, every tenet of that tournament, or World Cup, or World Rugby, or World Athletics, any tenet of that sport or tournament, you may find that it's either registered as a trademark or is registered. And few of them go under industrial design, such that they protect the exclusivity of using or associating with that brand without authority. That's how legally how we should. Why I present this, that I assume you are in your chambers and the client comes to you that you want to start a league, and then how do you protect it such that we don't wake up tomorrow and you find that any other person is calling this league the lawyers league. Is it registered? Then you need to register. You need to have your jerseys, you need to have all your marks registered in one of the elements. And our laws appreciate this better. Of course, those not in details as we may progress. These are brands, some of them are in services. You don't, that these are well-developed brands and people will be easy to associate with them without even the name. You don't have to see the word Mercedes. These are just brands that when you see, you know, this is Adidas, this is the name, this is Mercedes. These brands are developed from the innovators and then they are registered. The lawyers have a say in all these brands in terms of protecting them. You can't wake up and start your motor vehicle and you call it a Mercedes in this era. You cannot. You will be challenged. And that's what we also want to do in sport. If we say we are using the lawyers league, we want to register all the rights to it such that you don't wake up tomorrow and then you call your league lawyers league. It's the basic tenet starting from zero to be able to help all the lawyers on this platform. This is an example of football. I apologize, I need to do football where I've been working for almost 6 years that I appreciate better. And it's also applicable to other federations. So when you talk about a brand, the reputation, it normally goes with, as I mentioned, the legal business. This is where most of our legal business is as lawyers. You cannot talk about FUPA without its logo, without the word FUPA being protected under trademarks. Nobody is authorized to associate with it. You can't create the jerseys, you can't create the merchandise, you can't broadcast the game, you can't use one of these logos without authority of FUFA. And authority means you associate them with money, as we will continue to see. So once you register these trademarks for purposes of enjoying the commercial rights, you need now to protect them. Any lawyer, these are the best things we start with for the tournament. You leave the issue of training players to the coaches, but the legal business is in making sure that the brand is protected, that your client is exclusively enjoying the rights of that tournament or a federation or a sport in any way, be it cycling, that you can't call a tournament. There's no tournament without a name. And the question is, in accordance with the law, there is no federation without a name. So brand includes how you name it and how you package it in all the details and how you are protecting that brand. So we have a name. It normally comes with a logo, a slogan, a tournament emblem, World Cup. Those are slogans. And then we see all this Africa Cup of Nations. It's a name owned by a cup. In its entirety, you can't use it. Now, once you protect it, now that's where the issue of sponsors, where they are sure that this name, if I associate with Uganda Cranes as MTN, no other telecom company will pronounce itself as the official sponsor. And then for us in the practice, we make sure that no corporate company will associate or initiate any transaction with Uganda Cranes without the authority of FUFA. If it's basket, then without the authority of the basket federation. Even boxing, you cannot call yourself start a tournament in boxing without seeking rights from the boxing federation. So the branding part of it is key before we go into now how we enjoy the benefits of promoting a tournament and protecting it such that it's exclusive only to those that are authorized to use it. And as a lawyer, it doesn't stop only on creating the brand. The trademarks and copyright and the industrial design with URSB, you create a platform where you need to help your client. Either FIFA, that's for world, either World Athletics, World Cycling, be it FUFA, be it boxing here in the country, or even the Lawyers League. You must be able to protect its brand from infringement. That's where counterfeit advocates come in. You can't have your jersey and you call it Uganda Cranes and you sell it without the authority of the specified federation, or even Africa Cup of Nations. You can't start associating with it without authority of FIFA or CAF in terms of that. So it's a huge topic, but we must appreciate that we need a situation where we protect our brands for our clients to be able to benefit and attach ourselves to that journey. Now, after creating a brand with all its tenets, the names, the slogans, the media, the stadiums, the agreements, then this is how, for today's topic, this is how now we start to benefit. This is how revenue is delivered from the sport. The way most lawyers, we receive our money. After all the process, we go to school, we acquire a license, a PC, then how do we receive our money? It's the modes of how we some have retainer fees, others on salaries, some lawyers, most of them are on salaries. In-house lawyers, most of us are on salaries. This is how we get our money. But now in terms of sport, these are the 5 best. There are others, which we may not mention here for clubs, but most of the sports tournaments, this is how they revenue cripple from the sport or to the tournament, to their coffers, and then they facilitate. So the major one in the whole world is now media or broadcasting. That's where the most, almost 60% of the revenue from sports tournaments and federations, they receive their money for broadcasting. Then the second, which has been ranked the second, is sponsorship, as we see there in details. Then selling club merchandise, the jerseys, the club caps, and all other, and then licensing of trademarks, which we'll discuss in details, then ticketing and hospitality. These are the modes that have been verified to deliver income from a tournament, from a match, from a federation to the finances of that particular tournament, organizers or owners of the tournament or of the match. In Africa, if it's Africa Cup of Nations, it's the CAF, that's Confederation of African Football. If it's world football, then that is the Federation of International Football Association. If it's Uganda and Uganda Queen is playing, this is how FUPA. Basket, then it's how FUBA gets its money, even if it's boxing, cycling, athletics, this is how the money is acquired. And then, so as a lawyer now, we need to appreciate these 5 elements. How do we come in? How do we as a lawyer be part of broadcasting? Do I have any relevance in there? Yes, we do have relevance in all this, in terms of contracts, in terms of guidance, in terms of consultancy. These are how the business of lawyers needs to come in, because we are not going to go to the pitch to play or to run on the tap. We remain ours and then we guide, especially for the sports owners and tournament organizers. So we'll start with the sponsorship as the core from the guidance that we received. So what do we mean with sponsorship? As I mentioned earlier, that once we create a brand, we protect its properties, the name, the logos, the slogans, the package, the jerseys, and all that stuff that are protected through the laws, the national laws of a particular country, either through trademarks, if it is the names of the event, or the names of the tournament, or the names of the federation, the names of the football clubs, and the names of even some athletes are protected through trademark and copyright. If it's the jersey, we can protect it through the Industry Act. So once we protect now, the sponsors will start now to approach, to associate with an event. For example, World Cup, we've seen sponsors for World Cup, or Africa Cup of Nations, or World Rugby. We'll see McDonald's coming in to be the exclusive sponsor, to associate with that. And their benefits. They believe that once you sponsor an event, for example, in Uganda here, MTN is the official sponsor of Uganda Cranes. How do they benefit? They will indicate that instead of putting the money on TV to advertise for all my adverts, I would rather go and associate with Uganda Cranes, which touches the whole country. All the Ugandans associate themselves with their national team. So there is more viability and attachment. People will remember the official sponsor of Uganda Cranes when they go and watch a game either on TV or in Ambole than seeing an advert on TV. That advert, there are few chances that advert may be forgotten by anyone watching TV than them seeing their name on the shirt or in the pitch and everywhere, and adverts indicating that they sponsor the national team. There's that attachment they get, not only on through advertisement, but in several aspects. This company is with us, it sponsors our own team. That's why normally some uses it for their social corporate responsibility. So how do we attach to an event? First of all, before the sponsor comes, they need the exclusivity. That once I associate with the national team, the National Football Federation, it will be exclusive. I don't want to see any other telecom company appearing on any of your products, not even the teams, but even your federation. This is exclusive. And the first question is, are you able to protect me before I give you my money? And they pay huge sums of money. MTN sponsors the Uganda Cranes to the tune of almost 4 billion. It's huge money just to appear on the events and also associating as the official sponsor of the national team, the Uganda Cranes. So that attachment comes with a value. The federation receive money, or even if it's CAF, they will receive money. You see Ecobanks, you see telecoms. Now the official sponsor is now the energy company, Total, sponsoring being the official sponsor of the Africa Cup of Nations. All these comes at a value. The money would have spent into advertising on TV they come and associate it and pay to the federation, and all of the events are always, it's always not in kind. But sometimes it's not, as a lawyer, you need to appreciate that that sponsorship may not come as a financial consideration alone. Sometimes it is value in kind. We will sponsor in several aspects. There's a time we had a sponsor at a particular club, and for them, the only sponsorship was if you have a national, if you are traveling, we'll buy the tickets, we'll buy for you jerseys, we'll look for you for the venues, and they are not paying any cash. They provide that activity. So as a lawyer, you need to appreciate in that perspective, right? And what are the risks they normally associate with? They can come in terms of appearing on your shirt. We've seen sponsors in front of the shirt, be it Premier League or even here. Of course, this is sometimes restricted on the rules of a particular tournament. So as a lawyer, you must be aware, what are the rules of a particular tournament? For example, World Cup and Africa Cup of Nations, they would meet that the rules of those tournaments will not accept any national federation to put the name of any sponsor in front of the shirt. This normally happens in leagues, Premier League, Uganda Premier League. Most of the national leagues accept that. But international tournaments, they don't. So those rules, as a lawyer, you must be aware. But others, they go into promotions, stadium advertisement. Those are all forms of sponsorship. Appearing on your shirt, appearing on the stadium. So there are quite many that on a particular day will now go into details on how sponsorship can happen. But for purposes of today's presentation, we want to have a synopsis and be aware of what sponsorship in brief, what it means. This trying to give you a picture of how Uganda Cranes, MTN is the official sponsor of Uganda Cranes, and Nirvana. So MTN comes into the element of telecom. Now, FUFA, you cannot associate with any other telecom company in the world that competes with MTN as far as the official sponsor of Uganda Cranes is concerned. Nirvana comes in as the water, national, the exclusive Uganda Cranes water partner. You cannot associate, even the water you use on the pitch, on the camps, on the training, it's basically Nirvana. Nirvana gives you water and also consideration in a form of advertisement. And you will see on their bottles, they attach the logo of FUFA, and they also refer to themselves as Uganda Cranes. And when you look at their statistics, they tell you they have benefited more than mere advertisement on TV. They've benefited this association. So many people now know what Nirvana is all about. They believe it's a quality water. If Uganda Cranes, the players, consume that product, even the public believe this is the best quality or this is the best water that you can consume. It has benefits. Now, as lawyers, your duty is now to govern the contractual basis. How can Nirvana now be the only sponsor? Is it protected? Can any other bottling water company come and associate themselves with that product? It's now how lawyers will guide and how the contract is drafted and whether the trademarks, the slogans, the naming, and the commercial benefits of it are protected with Uganda URS bill and other legal entities in this country. These are all sponsors of Uganda Cranes, EcoBank, and other clubs are also benefiting from that. It's also the same also used to sponsor rugby. We have Nairobi Breweries. You've all seen Nairobi Breweries associating with the rugby union. It's one of the, I think it's the major sponsor in there. It's also sponsors Uganda Cranes, and you can't deal with any other product of alcoholic content without the authority of Nairobi Breweries. So these are tenants, the most common terms in a sponsorship. But I would prefer otherwise, you may have a sponsor. If the lawyer, you're not well aligned with the sports business, you may find that a sponsor comes and takes the products. Who may be the shirt sponsorship, you have water, you have medical, you have banking, you have telecom, you have Nairobi Breweries, you have beverage partner. You need to have a structure of you need to be aware. And when you are executing this agreement, you must be extremely and thoroughly very firm and clear that MTN, we are restricting you to telecom. You can't take away other rights. You can't take away rights of mobile money. You can't take away rights of banking. Because if mobile money is synonymous with banking these days, no, we're only restricting to telecom. If we receive any other sponsor in the form of mobile money, we'll take him. It's a form of argument and how firm you as an advocate is to protect your client's interests. Otherwise, if not, you may find that we have Nirvana, it's a water bottling company, and then we have maybe another beverage called like soda, Coca-Cola and Pepsi. Now, sometimes you find contracts where the Nirvana comes as a beverage company. Now, that will lock out other businesses like soft drinks. Now, as you're not aware and you insert in your contract that we are hiring or we are associating with Nirvana as a beverage company, now you are looking out what other beverage is. But if you are keen, widen the income of your client, then you need to be sure, how are we dealing with? Let me use an example. For example, have the Lawyers League now. Where if a particular company comes, a corporate company comes and say, I want to sponsor your league in terms of finance and giving you water, but it means I have to be the exclusive. We have companies that provide all the services, like the company that provides Rocco Boom, they have water, they have soda. So unless you are keen and say, no, we are taking you only for soda, if we get another partner in water, we'll take him on. That's how you widen your knowledge as a lawyer and then also be aware. That's the reason why we have these meetings and cluster discussions, to widen the knowledge of our client. And then the issue of exclusivity is very key when you are designing a contract. What are you giving that company and what are you receiving in return? It's very, very critical as a lawyer. It doesn't matter. The client need to be sure that, counsel, I want your confirmation that all other companies will not come and associate with you in the telecom sector. That's your duty now as an advocate, to make sure that you protect the brand from infringement. So it's very, very key. And also associating and appreciating the rules of other sports tournaments. As I mentioned, and CAF doesn't allow an Africa Cup of Nations. It's better you widen your knowledge, and as far as that is concerned. The scope is very key. As I mentioned, you may be sure what you are giving to the client, and in return, non-exclusive, the way you design your contract. You may have a client in telecom, and his value is giving you and you open it up and say, okay, MTN, and you're giving us this amount. And if Airtel comes in mobile money, non-telecom, we'll take them on because the money you are giving us is very minimal. It's now, it depends on the ingenuity of an advocate on who is your client. Now, if my client is the sponsor, from the experience I have right now, I would argue, I will not accept that. I will really insist that no, we take all the telecom money. And your client is a federation or a tournament or sports club, and you're not that smart, then I will take the day. But if you're smart enough, it now depends on how you insist. And that's why we do this kind of experiences, what we try to share with our colleagues on the platform. So you need to be very smart. There is business, but need to be very smart how we try to conduct and then also package the product to be sponsored by the corporate. Now, this is about the second element. We're done with sponsorship. And I'm sure you've settled now how companies or federations or tournaments acquire revenue from the sports tournaments or the games that they organize as a service where people come to be entertained, and then for them, they acquire money in terms of service. It's not only a ticket. The money we pay on the gate is not enough. Actually, records indicate that that money is only contributing to 10 to 15% of the revenue that clubs, federations, and tournament organizers receive in terms of revenue. So the second mode of receiving revenue is merchandise and licensing. Now, this, as I mentioned, if you create your products as a federation, I'm using an example of football here, but basketball, rugby, boxing, they have all protected their brands. And you can't wake up and manufacture or sell or deal in a brand or a national team of rugby jersey without the authority and find you selling it on the market. So you're not authorized to do that unless you acquire rights from them through licensing. But it's a double way. But some federations like football, at the moment, they deal with their sales directly. Have a shop, and also on Momo, they engage MTN that are branded. Without that logo Cooper and without that word Zakayo and those scarves, then that's not a product of football. It's not a product of Cooper. It's not. So you see that branding, the trademark, the designs that are protected, that's what gives it becomes a brand, and it is associated with football. So the buyers of these products, they don't buy it for the sake. It may not even be the best quality, but someone want to buy a Uganda Queens jersey with all intents and purposes. Not that it's the best design in the world, but you want to associate yourself with your country, with your game. Those who love football, some of us will love rugby. You find I have a jersey of the national rugby. So it's because the branding and its associates that I know this is rugby from the rugby union. That's why I'm buying it. It's not from any other company. Now, the challenge here is the counterfeits that we see. And Brian, you asked me to elaborate, as I will do. Yes, as a federation like football, we have kept on establishing jerseys. We started with kit manufacturers. Until now, FOFA established its own company because of dealing with the middleman. It was quite expensive. But the brands, the word logo, the logo, FOFA, the logo, the word Zakayo, these are all registered as trademarks with Uganda Education Service. Appear to be selling this product, either a jersey, a ball, these bags, without the authority of FOFA. If you do, then we take you on under criminal, under the National Sports Act, and then as an infringement, and a civil suit. We'll engage you and then we'll pay damages. And we'll try to do this, and it has one of the means of stopping the counterfeiters who infringe on these properties. So there are quite many that you can deal with it as your product. That's what we call merchandise. It's a source of income. But once that jersey is bought, that money goes directly to the coffers of the federation and then trickles back to the players. Now, how if you want to deal with those jerseys, either as a manufacturer or as a trader or as a subcontractor, then you need the word licensing. You need to acquire permission. It's that permission that we call licensing. You get a license. Now that license will have penalties as lawyers, depending on your capacity as an advocate. We'll have what we call exclusive, that you are the only party that will be authorized to do those licenses, not even the owner, like Cooper. Or normally, from practice, we give a non-exclusive that we give you, like Katuma Sports Center, you go and deal with the jersey, sell them, but we can also allow others to deal with the same product. So it depends on the discussions and the engagements that lawyers have with their clients. The critical thing you need to know who is your federation. Normally, you argue in terms of that respect. Who benefits the federation? Is it exclusive or non-exclusive? But in principle, I have not seen a federation assign right for the rest. We always license from experience. And we tried, it's a slide try to show you how we tried to engage, arrest counterfeiters, you engage the police, and this is one of the ways of protecting the brand. Because if you're just anyone can deal with it, then it loses value. For 50,000, jersey, we're still being in this country. Will not even cooperate in the appearing of civil suits, but normally this single trade purposes of evading because of mass sensitization. they are aware that what we are dealing with is illegal. It's a property of the federation. Even other federations in this country always use those means. These are counterfeits that normally you find you have a genuine product, and then others, because want to associate with that product, they go and create counterfeits. And then it's you, your lawyer, to try and find means to advise your client in the best way. Besides sensitization, what other modes to counter the counterfeit product? Engaging URSB police, UNPS, those entities are always engaged to make sure that we deal with the counterfeits. Now, the other major source of revenue in sports, federations, the clubs, the tournament organizers, is media rights. These are rights that are broadcasted on TV. For example, you find that a game, statistics will show that a game was watched by over 1 billion people, like World Cup games. They have genuine and efficient statistics to indicate that World Cup was watched by over 3 billion people in the world. We mean a world of 8 billion people. If 3 billion people watch your games, that's enormous. So this simply means that in Nambole, it's a stadium for only 40,000. But you find that over 1 million Ugandans have watched the game. Now, the rest, the majority always watch on TV. Now, that TV is a marketing tool. It's a broadcast mode. Put your game on TV, then advertisers will come and watch. If you watch Premier League, you find Guinness is advertising during the time of the game, Coca-Cola is advertising, Sunchat is advertising, companies come at that time because they know at this particular time when Uganda Queen is playing, 1 million Ugandans are all concentrating on this TV, this 90 minutes. This will come in form of adverts and they pay huge sums of money than online adverts. So as an advocate, if you're approached on a media contract, how do you start? And where do you start from? Passport comes to you that there is a game in Uganda and you want to be either the broadcast sponsors or we want that particular game. Normally, this is divided into two. They are broadcast company. For example, in England, we have the SuperSport. They become the broadcast sponsors of the league. Or in Africa, like Africa Cup may have SuperSport as the broadcast sponsor of the league in Sub-Saharan Africa, of the tournament in Sub-Saharan Africa. Now, all the rights pertaining to those games are owned by, the media rights are owned by SuperSport. SuperSport now is the one who has the right to share with others. Now, the key issue now is this has been dissected into several rights. Before, every sport broadcasting company or TV company will take all the rights pertaining to TV. This has changed with the modern era now. The federation, the tournament owners, they divide these rights. They no longer give exclusivity. No, they don't. On the table, this is an advocate of SuperSport, and this is an advocate of the tournament organizer or a federation. We sit on the table. And then we divert. Say, if you want live games, you want the game live, this is how much you want. Will pay us. If you are going to take it to free to air, that game normally, if your game is played, normally those rights are given for free for the country to enjoy. If you want mobile, people to watch your game on mobile, this is how much we need. If you want even on cable light, this is how much we need. You no longer take all the rights. So as a lawyer, you must now be able to appreciate direct to home, free to air, live, delayed, mobile phones, because a good number is from TV on mobile. So if you give all your rights, you may find that you're not benefiting from it. But you sell the mobile rights differently, TV rights, the TV sets, live games, the delayed replays, all those attendants have to be explained well. Giving me my whole money as a TV owner, as a tournament organizer like a CAF, FIFA, World Rugby, or we are going to share the revenue. And normally this happens. Some TV companies will approach you as a federation, a CAF, a confederation, right? I have sponsors. I have MTN, I have Airtel, I have Rugby, I have Coca-Cola. What we are going to do, allow me to broadcast your game. Now, when these sponsors come on board, we'll share 50-50. You take 50% of the advertising fee, I take 50%. That's how another mode. Or you insist and say, no, you give me $1 million, the rest you deal with your rights. As a lawyer, you need to understand the interest of your client and also how to deal with it. Now, some games are pay per view. You pay when you want to view. I've seen like this is normally common in the application, the mobile apps, like StarTimes. You can pay 1,900 to view one game and they close you out. Or you pay, so it depends on how your sponsor comes in terms of that. You may have UBC or NTV or NBS coming and say, me, I want the entire game live. And then you may have StarTimes or MTN coming and approach you and say, you know, can you give me the rights on mobile? I want to allow my people to watch on mobile. They will pay data, they will pay a certain fee. So it depends on how you structure your rights. And the period is very key. So you need to appreciate these rights as an advocate and that sell all the rights to one entity without that knowledge. So this is really to enhance, to awaken the giants, such that at least I know where, by the time we leave this platform, at least you have an idea where to start from. Mobile, TV, then there is the direct to free to air. At least when you are doing your research, you can know where to start from. Unlike before, where you didn't even know. TV company will now kindly normally come into and challenge us. So the other form is now the ticket. People, you buy tickets. Those of you watch Uganda Trades, I don't buy tickets to go and wear the Lawyers League because we feel it's not really a viable product. If you tell people you pay, I don't think that you will go and pay. There are so many games there where people don't pay because they believe the value is not worth it, me paying. I'd rather go and watch a movie than, so unless the product is built to the extent that people will now limit and then pay. So it's a source of income to the federation and tournament organizers. World Cup, World Rugby, athletics, boxing, you go in and pay before you access that game. And it's a form of income. But still, it also has several modalities. Either you, because normally these tournament organizers don't own stadiums. And most clubs that we know in this world don't own stadiums. Like Uganda Cranes, you host a game in Nambole, but that stadium is not yours. So what happens in practice, Nambole will say, okay, hosting a game, Uganda vs South Africa in my stadium, how are we going to deal with it? Are you giving me 200 million or you give me a percentage on every ticket that enters? So what favors you? And they will have an advocate. What favors the client? So normally what FOFA does, Nambole takes a percentage between 10 to 13 on every ticket. And they have tensor, they count the ticket. If your game is 40,000 people and you collect 600 million, Nambole will go with almost 80 million before taxes and all that stuff. So it depends on how you engage your client. Or sometimes you pay once, 50 million, and then you deal with the revenue. You don't care. So as a lawyer, you need to appreciate what favors your client as a business lawyer in this perspective. We can split revenue and then all retain all the revenue depending. Like a clubs. In most clubs in Africa here, if a club comes and hosts a game, they take all the revenue. The other club wait for you on their venue. In England, I think it's different. The Premier League takes a percentage and clubs also takes a percentage. So it depends on how each country and each game deals with its rights. Or you can engage a third party. There's a time I saw a federation, let me say, selling a particular game to this is what we call promoters, music promoters like KT, Balam, and said, for me, this game gave me 200 million, the less you deal with it. So some people go the risks in the game. So it depends on how, as a client and advocate, you must be sure on what you are exactly doing. And also some adverts can appear on the ticket. Other federations are very strict. They retain all the tickets and the rights. They don't deal with third parties. They want to be sure on what they are giving their clients. And some tickets are categorized. if you're advising your client terms and conditions. You may find there is a front view. This is an Arsenal game. You find there is a front view where you are paying that at £2,000. Beside the goal, the center, the back seating, all those tickets as an advocate, now you need to be sure. Because the client sitting in VIP is not the same as sitting in ordinary, where the sun is going to really challenge them. And other games dependent on how you advise your client to do this ticket. Because there are terms and conditions on these tickets for the buyer, there are rights that are created. So you must be aware on how to juggle with that kind of arrangement if you are approached by a client. Don't think that just design a ticket and sell to the public. No, ticket has categories, it has terms and conditions. So before you receive that revenue as a federation, your advocate must guide you that level of. Then the element of hospitality was also very key, how you take care of the clients. Now, hospitality is a source of income in that once you enter the stadium, there's entertainment. There are musicians that can be hired to come in. But most importantly, the refreshments, the beverages that you acquire in the stadium. You can't find, like, for example, right now when Uganda Queens play, or even World Cup, you cannot find any sort of, for example, besides Coca-Cola, you can't find any other beverage drink in terms of soda in the stadium. It's only Coca-Cola that is authorized in the stadium. It's part of hospitality, it has a refreshment. Because Coca-Cola is an official partner of FIFA or World Cup. You can't find Pepsi in that stadium. They will not allow that to happen. And that because Coca-Cola paid huge sums of money to be part as the hospitality, as the beverage partner of. So it's part of what we call hospitality, how you are taken care of. The cars that are used by players from Kia, the hotels also are part of that arrangement for those huge tournaments. So VVIP and VIP, the cost, all those are part and tenants of hospitality as commercial partners normally. So if you're approached by Pepsi, as far as World Cup is concerned, you will be kind enough to advise them, you know what? These rights are already taken away by the official partner of FIFA like World Cup. Here we have Nirvana. You can't find any other water. Not only inside the stadium, but even outside the perimeters of the stadium. It's because Nirvana is the official water partner. So we'll make sure whoever enters crosses the first gate. You can't carry any other sort of water, unlike Nirvana. So Nirvana benefits from that because it's the official sponsor of Uganda Queens. And that helps to appreciate, as far as hospitality is concerned, the benefits that are there. You find on one day, they are exclusive. You find they have sales of over maybe 100 million that they don't make in other platforms. Single. So this is basically about helping your client after now appreciating that. You don't stop at designing contracts. You need to help your client on elements of ambush marketing, on marketing. How would you help your client to protect its brand? Creating a brand, protecting it with the law is not sufficient. You need to protect it. You need to help your client protecting his brand as an advocate from counterfeits, IP infringement, ambush marketing, selling of counterfeit products, and ticket touting. And this always happens in our Queens game here. We've experienced it. You find people selling counterfeit tickets. We deal with the police to make sure arrest them, and then we write to them, cease and desist. Counterfeit product, you find national team jerseys being sold by the police, basically. Then if it's a corporate company, we write to them. We have initiated site for it. And 40 minutes are done. I will be waiting for you. And it's a huge topic. I want to confirm that if we talk about 110, its contractual benefits, the challenges, we cannot finish within this cluster, within the 40 minutes that was assigned to me. So I'll stop there for a moment. Over to you, Brian.
Thank you so much, Dennis. Wow. Thanks for the job well done. That was very rich and informative. You've taken me back to class. Please allow me very soon to join you for internship at Fufaligo. legal department. There is a lot to learn. There's a lot to learn. Dennis, there are a few questions. I'll start with Muliko Julius. Muliko Julius, his question is, how come jersey printing companies like Adidas, Nike, etc. are allowed to advertise on national teams' shirts, stock jersey, yet other and competing brands like telecoms or banks are prohibited? I think this is a question of kit sponsor, but you can give it a shot. Over to you, Dennis. You got the question?
Yeah, I got the question. Yeah, that's a wonderful question. Normally what happens, the rules, as I mentioned, the rules of a particular tournament organizer, like World Rugby, World Athletics, and in principle, they allow kit manufacturers, because that's the only way they benefit. Now, these manufacturers come in a way, if your product, like a tournament or a club, has enormous following, they will allow them to put from a small of 2x2, normally it doesn't exceed 2x2 or 4x4, the kit manufacturer only, either on the arm or on the chest. So that's the only rules that allow it, such that the kit manufacturers can advertise themselves. Otherwise, most of them don't benefit in selling jerseys. Some clubs and the federation, they insist they will sell their jerseys. They don't allow it to market on that. So they allowed it, but they don't allow other sponsors. So because it's just to show that this kit or this jersey is from Puma, is from Adidas, that's where they stop, just to show the origin of that product. And their trademark is one of the means of showing that it's from that particular company. That one is allowed.
Thank you so much, Dennis. From my side, I have a few questions. I'll start with the rights in a sports competition or tournament. In your language of sports law and practice, it's called primary rights holder. You have a tournament like CAF or CHAN. You have a tournament organized by, let's say, FUFA. In that tournament, the primary rights holder is FUFA, because they are the organizers and the owners of that tournament. They may choose to assign the rights in that tournament to a third party. Now, where FUFA or, let's say, an international federation could be FUBA, but from your practice in regards to your client, FUFA, where a tournament is organized by a rights holder, that rights holder enters into an arrangement. You've taken us through the sponsorship agreements, the relevant clauses, and all that. Now, these rights are signed or licensed to a third party. This third party may be, let's say, Uganda Breweries or Nile Breweries, whichever. Their rights are in the entire tournament to associate with Uganda Premier League, for example. From your explanation and presentation, does UBL or any other competitor that, or other entity that has primary rights in a tournament, do they allow these other, for lack of a better word, auxiliary brands to be associated with the tournament for as long as it's not a direct competitor? I'm a brewing company. I can allow MTN to come and participate, or it's an exclusive rights arrangement. By your explanation, the exclusive clauses were more to do with these other sponsorship deals. But throw more light on the rights in a tournament, whether the person owns all the rights and they close out other auxiliary brands, beverage and all that, etc. Thank you. Probably I'll raise others later.
Okay, that's a quite unique question. But if we talk about categories, as you mentioned, we have the international rights owners like FIFA, World Rugby, World Athletics. We have continental like CAF, and then the national like football or rugby or basketball. Those ones own the rights. Now, as I mentioned, it depends on how you tire your rights. as far as sponsorship is concerned. Because, as I mentioned, you have several categories. For TVs, they will always focus on broadcasting. Now, for these corporate companies, the providers normally come as sponsors. Now, as far as, for example, FIFA is concerned, when it comes to beverages, they will only take on an international level as their partner, Coca-Cola. Now, you will not find any other beverage as far as FIFA games are concerned, besides in the beverage company, that of Coca-Cola. But it depends on how we define that beverage. Sometimes we use it and then go ahead and say, as far as beverage is concerned, it excludes energy drink, it excludes juices, it excludes sparkling water, it excludes all these elements, such that when you get other partner in terms of juice, in terms of energy drinks, we don't take it as a beverage. Yet in English, plain English, that's a beverage. So how you tie your rights? But when it comes to national, for example, MTN, it depends on how you negotiate and the money, the value of their sponsorship and the value of your product. MTN now pays to a tune of 4 billion. Now, if MTN says, I'm going to triple that money and I want to be the only sponsor, then that can be negotiable. But depending on your negotiations as an advocate, the client, and then the willing sponsor, if the tune of the money is not worth taking all the rights, then you restrict them to the rights of telecom. We agree we will not have any other telecom company. To include telecom, to include mobile money, to include pay services, such that you don't use these other pay services like these cards, credit cards. Now, if you're an advocate, you are alive to that. Now, that service may be part of banking, and now banks will come also, and then banks also have mobile banking. So now how we negotiate with your client, that's how the rights that you acquire. But it depends on the negotiations. If you insist that only telecom, they will take telecom. If they stretch you to include mobile money, mobile banking, pay services, then it depends on that. Now breweries would come. For example, Uganda Cranes, now breweries now stops at beer. I know other federations where they go into whisks, they go into wines. But now here you stop at only beer, and the brand will restrict you to only Nairo Special. If you are bringing another brand, like Pilis now, any other brand now, you need to also, it will be another engagement as far as that is concerned. So in principle, it depends on how we negotiate and the rights that are already existing for continent and for World Cup.
Dennis, you've managed your time very well. We are very impressed. But one last question, one or two. One is on image rights, but because of time, well, you'd be the best person to raise an answer to this. But let me start with sports insurance. Not to players, that will be a topic for another. Probably colleagues will take us through a panel discussion on the rights of athletes. Will highlight on that. But on the sports insurance, a sports tournament is more like a concert, an event. Does your client insure its tournaments, or that is something that is gray in your practice? If a league or a serious competition or a given match that is organized by FIFA, where FIFA has rights, or CAF, if you have information knowledge on that, are those games or tournaments? But let me be particular. A tournament, a game, a match. Are they insured in case of anything, such that the person who invested their money, you have these third-party claims, our tickets, you have these brand and related sponsors, they have lost out on their investment and they want their money. Is there an element of insurance, or it's still the African or Ugandan way of doing sports business? Thank you.
Normally, let me start with the tournament that's alive to our minds, that we are going to, we have the federation and the country was awarded rights to host Africa Cup of Nations 2027. Now, part of the requirement in your offer to host your application, the first question is, do your government or party, do you guarantee that you will provide an insurance package to a tune of, normally they don't go below $30 million, but they assess They do $30 million because we are 3 federations. Each country can contribute $30 million. But now, what CAF asks, can you give us a guarantee either from an insurance company or an international repute that they will insure the tournament? All risks involved, minus they remove some certain risks that are provided for. For example, if an accident happens when the player is still in the air, through the aircraft, that may not be. Some risks are removed by the insurance companies. But in principle, yes, the games, the tournament is insured, and that cost is incurred in principle by a country or a federation or a third party that to provide a confirmation of insurance from a reputable insurance company to the tournament organizer, be it FIFA or CAF or World Rugby, if you are going to host a tournament.
Thank you. Lastly, as we prepare to have in the next speaker, Mr. Luganda, you have players who have their individual image rights arrangements. Let me say, Alex, you play for Vipers, and under Vipers, you have a contract with Airtel. You join Uganda Cranes, you're called, and the sponsor for Uganda Cranes is MTN. Now, in that arrangement, we have a conflict of arrangements. One, I have rights that I assign to Airtel, but at the same time, I'm going to be seen promoting the brand of MTN at a national level. How do you reconcile such cases such that players don't miss out on commercialization of their rights, image rights? At the same time, the federation is not seen to be muzzling the rights of these individual players, but also cashing in from the general sponsors.
Yeah, thank you, Brian. That's a very interesting. Normally, what happens these days, to summarize, is we, as a federation, you cannot stop a player from trading his image rights. Image rights belong to persona, it belongs to the players in principle. And that's what the recent case from Justice Mobile Commercial Court ruled. And it's an international principle. Image rights belongs to the player. Now, however, because we categorize, if the players on the pitch playing, their pictures and their skills and all that's are broadcasted. Now, when we talk about image, that we're going to trade the image of a player like Onyango, Atenga alone. Now, those rights, if he's an individual, those rights belong to the player. He's free to deal with it the way. Whether he's a player he has already signed with Airtel and our sponsor is MTN, we cannot take away those rights as a federation. We will inform MTN that among the players, we are aligning you, which is a composite of 4 and above, because we no longer deal with 3 players and below. We deal with 4 players and above with their consent. Mark my word, with their consent. Donning a Uganda Queens jersey. If they are not donning a Uganda Queens jersey with proper trademark and all that, those rights belong to the player. They are free to deal with them. So what we do, we give a player an opportunity to play on the pitch. But when it comes to using his image as an individual, he chooses which company he wishes to. So we'll inform our sponsor that, you know what, among the players we are aligning for you, with their consent, to participate in your activities. Kajubi brand is already sponsored by another company, is not part of this team. And that one, it comes directly from the agreement, the sponsorship agreement. We clearly highlight that the players, first of all, it will be on the consent of the players, joining Uganda Queens jersey, and we give you a composite of 4 and above. We learn out from the issue of individual. But if it's an individual and is willing and has no sponsorship with the other side, or with Airtel, and then that Airtel contract is not exclusive, we always engage them because they have agents. So basically, it's no longer a challenge, unlike before where we are not aligned with the image rights elements. For now, I think we are well aligned. A sponsor will be informed in advance. So as an advocate, if you slip on your the rights, and then you are liable to damages as far as the federation is concerned.
Thank you so much, Dennis. This is much appreciated. Members here, the Uganda Law Society members are sending in messages. They appreciate your insightful presentation. Young lawyers are asking how and how often they can reach out to you. I think in due course, ULS, under the leadership of the Sports Law Cluster, they will be reaching out to you to extend that olive branch to the young lawyers and other sports practitioners. Thank you so much, and I wish you a very lovely day. Members of Uganda Law Society, thank you for staying on. We have over 45 participants, and as we promised, we're 149, now 150. Thank you for attending in large numbers. We hope that we are delivering to your expectations. Our next speaker is Mr. Alex Luganda. The next topic is on lawyers at sports disciplinary hearings. An athlete's perspective. In this session, we shall explore the role of lawyers in representing athletes or sports persons during disciplinary hearings, drawing from real-life experience or experiences, and this discussion will shed more light on the vulnerabilities faced by athletes and the role of arbitration in resolving sports disputes, which will be the next topic or presentation by Mr. Dev Kumar. But for now, we're joined by Mr. Alex Luganda, who will tackle the aspect of lawyers at sports disciplinary hearings. Mr. Alex Luganda is a partner at Ahmak Advocates. Mr. Alex Luganda is also the director legal at Vipers Sports Club. Mr. Luganda is also the Minister of Justice and Constitutional Affairs or Attorney General of Busoga Kingdom. Mr. Alex Luganda has a very rich CV. He's the legal counsel for Uganda Premier League. He's also the member of the Appeals Committee of the Confederation of African Football, CAF, in Cairo, a position he held, I think, from 2012 to 2017. He's a FUFA accredited football management and administration instructor from 2012 up to date. Alex is also a panelist on the panel of experts, the National Statutes Committee, Geneva. He's the secretary of the African Legal Forum for National Red Cross Society, the advisor. Very rich CV. Mr. Alex Luganda has been in the sports space for a while, and I think the members on this call are delighted to have you, and we're excited to learn more from you, especially on this topic of lawyers at sports disciplinary hearings. Over to you, Mr. Alex Luganda.
Well, thanks very much, the moderator of this session, my brother Brad, and to my fellow panelists. I've just been listening to Councillor Dennis Lokambi, and it was quite a very insightful discussion on that particular topic. I also like to say, when he was closing, there was the concept of image rights, which is a very, very key issue affecting athletes and sports, even in Uganda right now and the world over. And I just felt I had something very brief to say on that before I delve into this particular topic that had been given for today. I just wanted to highlight that the issue of what amounts to image rights does not have a one-size-fits-all definition. So it is very important for us as lawyers and legal practitioners in this area of sports law to appreciate what definition is applicable to a given jurisdiction. But what is important to note in general application is the concept of the definition that image rights refer to your individual proprietary rights over your personality to prevent the unauthorized use of your image, your likeness, your name, your nickname, because right now we even have concepts of nickname. And then new areas have developed, including tattoos. Tattoos are part of the image rights, and animations like the artificial intelligence video games and so many of those other things. So it's very important for us to have a very broad appreciation of what exactly image rights mean. And then when you're signing on players, you need to sign a different image rights agreement with them, which is different from the contracts you sign with them as players. But it's a very wide topic for discussion. And I think since we shall be having more of these trainings and sessions, we'll come back to it more comprehensively. It's one area, Brian, I think we can even have a full day session dealing with the component of image rights of players and athletes in that regard. But thank you very much for hosting me, and good morning once again to all the other members who are tuned in and following this discussion. The topic I'm dealing with and had been requested to deal with is in respect to the rights of athletes, rights of players. I usually prefer calling them athletes because of the wide scope of the sports arena, because we have different games and sports during disciplinary proceedings, and then the role of lawyers in those processes or proceedings, and then what possible challenges are affecting us in the conduct of this business. I would like to first of all start by highlighting that the best practice in the sports field is that disputes that arise from sports-related engagements should be resolved within that specific field or sport. The background to this is that the civil courts or the municipal courts that usually handle civil disputes or criminal disputes as between citizens may not be possessed with the necessary skill set to offer dispute resolution as far as the specific sports-related disputes are concerned, on top of the bureaucracies and the red tape involved in the normal operation of the court system. So, for example, you go to court, the procedure is that you file your pleadings, then you have to serve the other party. The registrar may not be around to sign. Then if you're in the High Court, for example, in Uganda, you're given a hearing date, which is 3 months from the date you filed. But if the nature of disputes is involving transfer of a player from one club to another, or rights of a player to play in a league, or it's involving a penalty or sanction that has been given to a club and the club wants to challenge the same, then it becomes very detrimental to sports, because sports in itself moves like a river and it moves at a very fast rate. So the nature of dispute resolution mechanism must be designed to support the same. I will also, I think, try to look at Uganda as a country before I move to the region or to the global context, because majority of those following this are Ugandan legal practitioners, with exceptions of a few, like my friend Dev Kuma, who is a long-time colleague and practitioner of sports law. But as a country, we've recently celebrated the enactment of the National Sports Act, which came out last year. the 2023 National Sports Act. And the National Sports Act is also a bit shy in providing very clear dispute resolution mechanism for sports management, because it makes reference to arbitration as a mode of resolution of sports dispute, but at the same time, it makes reference to the minister, the responsible minister, making regulations for the establishment of a national sports tribunal, which in essence would be helping to resolve the disputes. Because if you're telling people don't go to courts, then you must be in position to show them where to go, where you want them to go. And in this context, the government, we in the sports arena are calling upon the government now to move the step forward, the minister to enact the regulations such that we have a sports tribunal established within the country. I'm making this background such that the members listening need to be put into context, because you will invite members to participate, to learn how to participate and represent clients in a sports tribunal, but then they will not find that tribunal existent. And it is important that we call out all the key players such that we advocate for the fast enactment of the relevant regulations to establish the same. We've seen countries with robust systems for sports dispute resolution and arbitration, like Kenya, because Kenya has a full arbitration tribunal for sports set up by the country. And it basically deals with disputes to do with doping violations, issues with transfer disputes, players and club disputes, agents and intermediaries disputes, among so many other things. And in there, the rules establishing those tribunals clearly set out the rights of the players as far as their appearance in those tribunals is concerned, but at the same time, what are they entitled to and what are they not entitled to? So it's important that I'm bringing that in context for us to know, and for the sports lovers and the sports legal practitioners to also add your voices to the need for us as a country to move very fast in that regard. The other component is when we directly now come to the rights of authorities. In Uganda, we have the different sports disciplines, but most of them do not have very clear dispute resolution infrastructure set up, save for a few like football, I think basketball, swimming, I think has some semblance of infrastructure. Now, like for example, FUFA has, like FUFA in Uganda, which is the National Association for Football Management, has a structure that is akin to the FIFA structure, because it has the adjudication, the football adjudication chamber that has the other bodies like the Players Status Committee, and then which goes on to resolve a number of disputes that internally happen with between players, their clubs, between clubs and clubs, between coaches and clubs, among others. But for us to clearly appreciate our role as lawyers in this process and the rights of the football players or the authorities, I'll, for example, use the example of the FIFA structure. Before 2021, before October 2021, FIFA was running parallel disciplinary or decision-making bodies. It has the dispute resolution chamber on one side. It had the players status committee on the other side. And there were players or stakeholders within the system, like the agents and intermediaries, who were not provided for expressly. So in October 2021, FIFA undertook changes within its regulations and established what is called the FIFA Football Tribunal. So the Players Status Committee, the Dispute Resolution Chambers are all now merged into one organ, one body, which is called the FIFA Football Tribunal. And in the FIFA Football Tribunal, you have the Dispute Resolution Chamber as one of the organs. You have the Player Status Committee as one of the organs, and the agents, what we call the agents chamber, as the third organ. I'll briefly tell us what each of these does, because for you as sports practitioners, it's very important to know that when a sports dispute arises, you need to answer two questions. What is the nature of the sports dispute that has arisen? Is it of an international dimension, or it's of a national or local dimension? So, for example, in football, if a dispute has occurred and it is of a national dimension, it is involving players within the same league, all of the same nationality, they are Ugandans, all coaches, Ugandan coaches with the Ugandan club, then those matters are of a national dimension, and they can be referred to the FIFA adjudicatory bodies as first instance bodies. And you can only make reference to, for example, the Court of Arbitration for Sports as appellate mechanism after exhausting the local infrastructure, adjudication infrastructure within the country. But as lawyers, the moment you discover that the nature of dispute is of an international dimension, to bring you into context, for example, if you're having foreign coaches or foreign players, and then a dispute arises as between those players or coaches and their clubs in Uganda, or you are having transfer of players from Uganda to another country or another association or jurisdiction, then if a dispute occurs within the conduct of such kind of business, then it has to be referred to the jurisdiction of the FIFA tribunal, FIFA Football Tribunal. And I'll run now briefly before I go into a summation of the rights, because the component of the rights are usually the basic rights that we have for parties within proceedings. And I know Dave later on, when he will be talking about CAS and so many of those, because it's one of those tribunals available, he will expound more on those components. But I wanted to go briefly on what is the jurisdiction. For example, with DRC, which is the Dispute Resolution Chamber, what does it do? Where does it have its mandate? The Dispute Resolution Chamber, for example, of FIFA, resolves disputes, for example, employment nature between clubs and players of an international dimension. You have a player in Vipers, for example, you got that player from Nigeria or Congo, and you are having disagreements over implementation of your contract, then the player can run to the Dispute Resolution Chamber of FIFA or the Player Status Committee, depending, provided the nature of dispute is of an international dimension. Then it also deals with issues of compensation, training awards, and then the solidarity mechanism payment. And that still deals with transfer of players and entitlements to clubs that were involved in the nurturing and early stages of a player. So in the event that a player is sold from maybe Kenya to another club in Italy, but there is a club in Uganda that is entitled to solidarity payment or compensation training awards, then such a club can easily go to the Dispute Resolution Chamber of of FIFA for purposes of lodging a complaint in that regard. Then you have the Player Status Committee, which is also the other body, adjudicatory body. It deals with disputes between coaches and clubs of an international dimensions. It deals with transfer-related issues to do with the disputes of ITC and others. Then eligibility of players to participate in certain competitions and a number of those other issues. You can easily see them when you look through the regulations governing the operations of these FIFA football tribunal bodies. And then finally, the other issue is the agents, because the agents now have a chamber for themselves as far as dispute resolution is concerned. Then these ones deal with the issues of agents, disputes between agents and intermediaries, agents and players, among so many other things. I'm broadening it beyond the concept of merely players' rights and what is your role as lawyers, because your role as lawyers will be to understand how do these mechanisms operate, since you will be in charge of advising your client where to go, which place has jurisdiction, where do you take which kind of dispute. Because it is very embarrassing when you, as a lawyer, in execution of your role, you take a dispute to a court or a tribunal without jurisdiction. Then you are told you file this matter before the dispute resolution chamber, but it is one that should have been filed with the agent's chamber. So it becomes an impeachment on integrity, but also a professional breach on your end. And that's why in navigating the topic that has been given to me by the organizers of this symposium, I felt it vital that we share something to give us a broader picture of what is happening as far as the dispute resolution infrastructure and the mechanism within the sports management around the world is concerned. Also, it is important for us to know that after 2021, there are some changes that have been made and have happened, mostly with football. I will speak about football because it's one of those most regulated sports we have, but also most of the time they elicit a lot of dispute because of the nature of commerce. Right now, and I know Dennis myself spoken about it because I joined late, but the commercial value of football alone, if you're going to estimate it, is in billions of dollars annually that comes in. So the more money that comes into the business and the field, the more likelihood of dispute arising is. So in 2021, the FIFA carried out amendments to its regulations on status and transfer of players because there were challenges to do with the costs involved. So right now, where, for example, under Article 25 of the amendment, if the dispute to be lodged with the player status committee or dispute resolution chamber involves a player, involves an agent, involves a coach or intermediary, then the filing of the complaint is free of charge. And this is done for purposes of facilitating easy access to justice for players, since we are looking at what are the rights of players. And as we shall later on see, at times the costs involved in seeking resolution of disputes chases away potential victims. I know, and this happens mostly when we have matters filed in CAS at the Court of Arbitration for Sports. But I know Dave, when he's giving his presentation around CAS, will be in position to share with us what are the financial implications of filing complaints or actions or matters in CAS, and what does it mean to economically not very empowered parties. I remember at one time, even locally here, we've had parties running to the Court of Arbitration for Sports, but when they are issued bills for preliminary receipt of their complaints, because part of the CAS framework will not accept your pleadings or your complaints unless you deposited a given amount of money, around 20,000 or around there, for just for the beginning, before they even move ahead to appoint arbitrators for you, whom you also have to agree on payment. Most people have failed to pass that first hurdle. So in the enforcement of rights of players, of coaches, of intermediaries and agents through these disciplinary hearings and dispute resolution processes, the issue of commerce and financials becomes a very, very key consideration. Brian and the listeners, I will now just briefly get down to looking at the rights. If we are not talking about players, for example, what are the rights of players when they are before these tribunals or disciplinary proceedings? One, they have a right to be heard, which is a basic right, and I will not really dwell a lot on this particular issue because I'm sure we being lawyers appreciate that. But what is important to note when you get down to participating in these processes as lawyers is that the rules applicable, the law applicable may vary. For example, in Uganda, we were talking about image rights a few minutes ago, and you will say, if you're dealing with image rights, which particular law applicable are you using as a lawyer when you're coming in to advise? Now, and it cuts across a number of issues. So we usually use a bundle of different laws, a buffet of different laws to put across to seek remedies for our clients. For example, if you're dealing with image rights, you'll deal with the privacy law, which is now under the Constitution of Uganda, the right to privacy. You'll deal with issues of intellectual property, issues of the Neighboring Rights Act and Copyright Acts. You'll deal with issues of the contract law. You'll deal with so when you are coming into the aid of your client and advising them, we usually run a spectrum of laws. The National Sports Act of 2023 has attempted to codify a number of issues, but still it hasn't been sufficient in covering the broader spectrum of the different rights. But as far as procedure itself is concerned, the ordinary procedure we use in the municipal courts or the civil courts will not necessarily apply. So issues of the Evidence Act, in case we are having proceedings, how do we tender in evidence? Does the Evidence Act apply to the latter? Not as such, but the tribunal, the specific tribunal before which you are appearing has a legal regime that govern it. And among others, they usually address issues of procedure. Like if we're proceeding under the Player Status Committee of FIFA, you will be advised by reading through the status and transfer of players regulations of FIFA. You will be told that for these particular proceedings, you have an option of submissions. for these particular proceedings, you can have an option of appearance, physical appearance. In case you are proceeding in a language that the client is not comfortable with, the player or the authority has a right to interpretation. Interpretation into a language that they understand, such that they're able to follow proceedings. Issues of witnesses, that you have a right to bring witnesses to support your claim. Although most of the time, for purposes of facilitating expeditious resolution of the issues, you will be advised to file submissions, written submissions in support of your respective claims with the relevant authorities, because there are a host of authorities that have been litigated upon in the component of sports law in the different jurisdictions around the world. The other elements I would want to speak about, sorry, Brian, I didn't do a PowerPoint presentation because this is an area that is developing. We do not have existent infrastructure within the country that we say we are pinpointing. And I was rushing into another board meeting where I've just stepped out to make this presentation. But another area of interest for rights, for example, for players and authorities, is the right to a fair hearing. And this is one area that is still developing, because in the right to a fair hearing, there is a matter that was decided by the European Court of Human Rights sometime in 2018 between Mutu, I think was a Romanian football player, and then Pechstein, who was a skater, a German skater, versus Switzerland. This had been banned because of doping violation, and they had been banned. They challenged the decision of CAS on the component of impartiality and bias, because they were claiming that they did not have opportunity to choose arbitrators of their own, and CAS was biased in that respect, because even the list of arbitrators given to you when you file in CAS is a closed list. So you do not have clear control over and influence over them, or you may not necessarily trust their neutrality in the matter. And this is one of those controversial decisions. I will look out for the citation for the same, but it's a decision that was meted out by the European Court of Human Rights around 2018, involving Mutu and Pechstein versus Switzerland. But the appeal against CAS decision was dismissed by a majority of 3-2 of the judges of the justices of the European Court for Human Rights, because they dismissed the appellants, Mutu's contestation of the impartiality, neutrality, and compliance with the rights to a fair hearing by CAS, noting down their rights under Article 6 under the European Charter of Human Rights. There is the component of Article 6, which gives the rights to a public hearing and a fair hearing, and they're saying the way CAS conducts its business does not necessarily meet that requirement. So although the court agreed with them on certain elements to do with independence of the members, they must be neutral, but then court did not agree with them finally in total, and dismissed the application, because it noted that when the players, authorities, and coaches participate into these games and sign on to the regulations, to be bound by the regulations, then they waive the right to certain rights that would be ordinarily amounting to a fair hearing within our municipal court systems. So the moment you do sign on to to be bound by the regulations and so many of those other rules governing the respective games you are participating in, then you waive off some rights or certain rights that ordinarily would accrue to you as an ordinary member. So, Brian, the time factor may not allow me move into so many other things. I would want to wrap up in the next 4 minutes by saying that, one, as lawyers coming to practice in this area and engaging our clients in disciplinary proceedings, guiding them through, we have one obligation. One of the obligations is we must know the law, we must know the regulations, we must know the procedures involved. Because if you're going to be the lawyer, then you are the eye, you're the client's eye and ear and hand and leg through this journey. So you have an obligation to acquaint yourself with the same. Then also the other obligation is before the actual dispute arises, to advise the client when they are entering the respective agreements and contracts with the clubs, with the associations, because as lawyers, we are supposed to be advising these players and athletes before they get into the various contracts for purposes of ensuring that the contracts prepare for dispute resolution. And at times, you need to be very specific in respect to certain components like arbitration, the seats, and so many of those issues. Mostly in countries like now Uganda, where you do not have a very clear established tribunal. And the existing law now refers you to ACA, to the Arbitration and Conciliation Act, as a source of dispute infrastructure in case of post-contract misunderstandings. So as lawyers, part of our role will be to ensure that we advise the clients quite well, even before the disputes arise. Finally, the challenges we also expect and are experiencing is that we lack a legal regime, a robust legal regime that is guiding on these operations. That is why I will not get down to discuss so many details, because I will be quite hypothetical in the absence of a clearly established legal regime to govern how we are operating. So thank you very much, Brian and the team. I would like, for purposes of this presentation, to end here, unless there are any other specific issues on which the members listening in would love clarity. But it's also a very huge topic that requires quite some time if we are going to navigate it through from the start to the end. Thank you very much.
Thank you so much, Alex, for that wonderful presentation. Members are really appreciating. You've managed your time very well. I meant to understand that you have a board meeting in a few. Actually, you just stepped out. Thank you for sharing with us and sparing your time. Our next speaker has just joined us. That is Dev Kumar. He's going to take us through what Alex has been referring to. Maybe before he comes, Alex talked about player rights, some questions that have been framed from the participants, and a few that have come up with or crafted after your presentation. I think they will be answered by the panelists during the panel discussion. We are joined by Mr. Ivan Magom. He's going to take us through players' experience at the disciplinary stage, and also he will share with us other inherent or otherwise rights of athletes and how they are protected under the law. So we shall have a panel discussion around your topic, Alex. So to save time, I will direct those questions to my panelists at around 12 something. Another insightful, rich topic is going to be presented by Dave. Dave is a celebrated sports lawyer, celebrated international sports lawyer. He also doubles as the academic director at ISD. Dave is a pro bono counsel at FIFA, but also offers pro bono services to Uganda Law Society sports law cluster members. Every time he's called upon, he's willing to share and train sports lawyers at international level. The first time I met Dave, he trained me in 2019 under Uganda Olympic Committee arrangement. The training was very, very insightful, and many lawyers benefited. Ever since then, he's been willing to train Ugandan lawyers on an international level, sharing his experiences with rich exposure. Dave is also an arbitrator at the Sports Resolutions Safeguarding and Management case. Dave is also a panelist as Sports Resolution Chair of Safeguarding Commission at the International Mixed Martial Arts Federation. Dave also is an arbitrator at Esports Dispute Resolution Tribunal. He's also a panel member at the Disciplinary Committee at the Fédération Internationale de Volleyball. Dave is also the managing board member for integrity at International Boxing Association Advisory Board. He's also a board member at the Football Foundation for Africa. Dave is the legal and governance director at British Volleyball Federation. And lastly, Dave is also a sports agent. Dave, you're most welcome. He's going to take us through sports arbitration. Under our national law, that is the National Sports Act, there is mandatory arbitration. The law around section 56, 57 considers a constitution of a sports federation null and void if it does not have a clause on arbitration. It's what Dr. Donald Rukara was referring to as an Oster clause. Practitioners have been used to contractual arbitration where parties just agree, but in this act, it is mandatory. So you can't take your dispute directly to High Court unless probably the law is amended. So in our laws, we have that mandatory arbitration, and colleagues here, the lawyers on this call, they are familiar with the general arbitration, but now they need expertise in sports-related arbitration. How are sports disputes resolved? Do they take the same route like the ordinary arbitration? Is there a way I can run away from CAS? For example, I choose to go to Supreme Court of Uganda. If I'm dissatisfied with the CAS, can I go to the European Court of Human Rights, ETIS, and all that? So, Dave, you're most welcome. Over to you, and we're excited to learn from you. Share with us your personal experiences in this field of sports arbitration. You're most welcome.
Right. Good afternoon. Can you hear me? Am I audible?
Can hear you very well.
Excellent. No, thank you very much, Brian. Thank you to everyone that's here and participating. It's always an honor for me to come back and to assist the Uganda Law Society. And as Brian has mentioned, we've been engaging with each other for several years now. And it's no less a pleasure for me to be here with you in 2024 than it was back then. My name is Dev Kumar Parmar. I won't go through an introduction because Brian has introduced me far better than I could introduce myself by raising a number of titles that I'm honored to hold. But the main point really through all of that is that I'm working in sports full time. I've been working in sports full time for a number of years now, close to a decade and a half. And I dedicate my professional practice and basically my life, I could put it that way, to sports law, sports regulation, sports arbitration internationally. Now, the one thing I would clarify is that I'm not a sports agent myself. However, our offices deal with around 15 or 16 different agencies. So I'm often charged with and I'm often involved with dealing with transactions relating to player registration, particularly in football. So we are involved in the transfer market quite heavily, in the winter market, which will be coming up in a few weeks, and also the summer market, which of course will be next summer. And we deal with transactions which are local at national level and at international level, from the English Premier League to Serie A, right through over to China, to India, to Saudi Arabia, and so on. So it's something that, of course, if it pops up, if anyone's got any questions about, then I'll be happy to assist. Now, what I would like to do is, rather than simply speaking at you guys for a short while, I'm mindful that we've got other panel members here as well. I invite their interaction if they've got any backup points to what I'm saying, and I invite your interaction. I know that we've got the webinar chat, which I've been following for the last few minutes whilst my dear friend Advocate Luganda was speaking, and I also put on the citation for the Mutu and Pechstein case there for Kushaba, who was asking. So please keep interacting on the chat. If you've got any questions, please put them through, and I'll do my best to assist. With regards to the pointer that my friend Brian started off with, CAS, the Court of Arbitration for Sport. Can we run away from CAS? Well, the short answer is yes, you can run away from CAS. The more detailed answer is going to focus on how you can run away from CAS and in which instances. Because what one will often find is when you're operating in the mainstream sports, there's little opportunity to run away from CAS. Now, what Advocate Luganda had mentioned with regards to Mutu was very pertinent, particularly if we go on to the point of receiving a fair trial. Now, the composition of a trial, the structure of a trial within the private law context has always been a controversial thing. And the brutal reality is that in most instances around the world, if you look at the composition of the trial and even the structure of the procedures leading up to the hearing, if you then take that and compare that to what you might expect in an ordinary legal system that has been raised under democratic principles, it won't match up. It simply won't. However, there are other points of significant benefit that have often led to the dilution of the necessity for having a trial held in the most fair way possible in sports. And this is something that, of course, was challenged by Adrian. Adrian, someone I know very well, or I knew very well. I haven't spoken to him for years, but he was a client of ours about 10 years ago. We didn't handle his case at the European Court of Human Rights, but I was fairly close to what was going on back in 2014, 2015. And Adrian challenged this alongside Claudia Pechstein. And of course, as was seen, it was determined by the European Court of Human Rights that, at least in one instance, Adrian and Claudia had not, let's say, tacitly waived their rights by following the CAS proceedings, and therefore the fairness of a proceeding at the Court of Arbitration for Sport was questioned. Now, we've got to be careful about how much impact this really has. because this is something that can be and has subsequently been dealt with quite simply by the Court of Arbitration for Sport. The first thing is merely ensuring that everyone has got that ability, in theory anyway, on paper, to be able to ask for a public hearing if they want to. We saw that quite soon after the decision was being made from the ECHR, where, for those of you that follow swimming, and of course my dear friend who would have been with you earlier today, Dr. Donald Rukare, will know, we had the case of the Chinese swimmer, Sun Yang. Now, the Sun Yang case was the first case that was held by CAS and was heard in public. It was streamed live on a WebEx link. WebEx is basically the same platform as Zoom, but it's used on a more corporate basis. It was streamed live on a WebEx link when the case was held several years ago, and it was a remarkable thing to watch. That in itself led to other legal situations arising, because people called into question the actual legality of the procedures and the balance of the rights that had been afforded to the parties. But nonetheless, the decision that was made against the Court of Arbitration for Sport, or against the Swiss law principles, which affected Muto and Bechstein, are relatively easily dealt with. And the challenge that we've got, if we want to run away from CAS, using the words that my friend Brian mentioned at the start, would be that the IOC, the International Olympic Committee, which of course sits from a pyramidical system right at the top of the sports pyramid globally, the IOC has written CAS into its statutes. Furthermore, underneath the IOC, if we look at the overall sports pyramid, we then have all of the international federations. So we have FIFA for football, we have FIVB for volleyball, we have FIBA for basketball, we have World Athletics, World Aquatics, so on and so forth. All of these international federations have, in theory, got autonomy with regards to how they want their dispute resolution mechanisms to be dealt with. However, out of that, FIFA, as a very quick example, has written CAS into its statutes. So any matter that is raised within the FIFA Football Tribunal, which would be dealt with by the disciplinary committee or by the player status committee, where a decision is rendered by a FIFA judge, can be appealed at the Court of Arbitration for Sport. It can only be appealed at the Court of Arbitration for Sport. Now, if we look at it in terms of each sport in isolation, we could say, okay, that's just football. Correct. So let's forget about the other sports for a moment. Let's forget about volleyball, basketball, tennis, everything else, just for one moment. Football is just one sport. So we've got the IOC that writes CAS into the statutes. The IOC is only really handling competitions every 2 years on 4-year cycles, right? So we've got the winter and the summer games. Okay, so you have ad hoc panels that take place. The first ad hoc panel that took place at a games was in Atlanta 1996, if I'm not mistaken. And essentially that means that they convene a bunch of arbitrators who are there ready to deal with an expedited hearing if an issue arises during the games, so that they can be there, they can be present, and if a doping matter or an eligibility matter or something like that arises, they handle it overnight or sometimes during the day even, to ensure that the competition, the timetable of the competition, remains sanct. If you look at it from the perspective of a sprinter doing the 100 meters, often the heats would take place the day before the final. The heats and the semi-final will take place the day before the final. If an eligibility issue arises from the heats or the semis, you can't go to the state court to deal with that issue, because that's going to compromise the the timing and the integrity of the entire competition. So it needs to be dealt with within 12 hours to ensure that the final can still go ahead and it can still go ahead in a fair manner for everyone involved. So CAS ad hoc panels started over with the IOC in 1996. They've been running at every Olympic Games since then, but they're only for 3 weeks every 2 years. And then we look at it and say, okay, FIFA. But FIFA is, as we'll all agree, whether you follow the sport or not, it's the most popular sport in the world. It's the most played sport in the world. And it's the biggest money generator in the world. So even if we don't consider any of the other sports for a moment, straight away we're talking about the IOC having CAS written into their statutes, right at the top of the global sporting pyramid. And then we've got FIFA, arguably even more powerful than the IOC. So from a pyramidical perspective, they fall underneath the IOC as an international federation of a sport, but more powerful in terms of its populace and its finance. And they've got CAS written into their statutes. So if you've got any issue that arises in sports, straight away, the chances are that you can't run away from CAS. However, we have further delineations. Now, I mentioned that if we look at it from a FIFA perspective alone, any matter that goes into the football tribunal, and that could be a dispute between a coach and a club, or a player and a club, or two clubs, any matter that goes into the football tribunal, the private mechanism of FIFA will take it through a process. That process would be adjudicated over by a FIFA judge, and the FIFA judge would render a decision. That decision can then be appealed to CAS. You've got 21 days to appeal to CAS. The deadline is sanctioned. If you don't appeal within 21 days, then the ability to appeal is finished. It's a private law decision, so it cannot be addressed, in theory, anywhere else. However, FIFA now has a mechanism where it's opening up the ability for its 211 member associations, and let's be emphatic here, FIFA has got 211 member associations around the world that administer football in their own jurisdictions. That's more than the number of signatories we have to the United Nations. So again, we just emphasize the power of football and the power of FIFA. But it's now emphasizing to its 211 member associations that they can have their own national dispute resolution mechanisms. This is something that was formally put into place in January of this year, where the invitation was that each member association should set up its own fair, impartial, and independent national dispute resolution mechanism in line with FIFA recommendations. And if you can do that, if you was able to put one of those forward, if the Real Federación Española de Football in Spain was able to put that forward, if FIGC in Italy was to put that forward, then you can deal with disputes locally without it having to go to the FIFA Football Tribunal. And of course, if the dispute can be dealt with locally, then it might be that CAS is not the appeal mechanism. So going back to the question that Brian put, how can we run away from CAS? Even in the world of football, generally, it's very difficult to run away from CAS. However, if we're dealing with a situation in a country that has a recognized national dispute resolution mechanism, then any dispute, whether it's dealing with national parties or foreign parties, can be dealt with in that body. And then the appeal for that body would usually be the local state courts. So an example of that might be what we have in England in football, where under the rules of the English Football Association, we have an independent football tribunal which is outlined in part of Rule K of the Football Association statutes, and therefore it's colloquially known as a Rule K arbitration. This arbitration mechanism is deemed to be sufficiently fair, impartial, and independent to the extent that if any issue arises in football in England, it's dealt with by a Rule K arbitration, or in some instances by the competition organizer. So we've got an English Premier League arbitration, which some of you might have heard about recently, because one particular club has got 115 charges applied against them, and that's been quite big news. Or we have an EFL tribunal as well, which is for the English Football League, the Championship, League One and League Two, out of the 4 professional leagues we have. The appeal mechanisms for any decisions that like this would be to go to the state courts. So straight away, we have a situation where we're dealing with the most popular sport in the world, in arguably, it's not always agreeable, but arguably one of the most important countries in the world with regards to this particular sport. The global governing regulations, or the statutes for this sport, outline that the Court of Arbitration for Sport is where you would appeal a dispute, but you can actually funnel through a totally different route. And you can see that in a few other countries as well, but it's literally just a handful of the 211 member associations right now where you can, in inverted commas, run away from CAS. So CAS is still the most important body in sports dispute resolution, and it will remain so for a while. We practice at CAS frequently. We're very well known at CAS. I don't know if that's a good or a bad thing, but we practice there frequently, and there are many good points about this. There are benefits to the sports arbitration mechanisms in play. And even though we have some technical concerns with regards to, again, a right to a fair hearing and various other points, the simple reality is that it works in general. It works quite quickly, and it works with a genuine understanding of the sporting mechanisms. The ideology of Lex Ludica, which is a principle of a developing body of sports law, sports jurisprudence, fully understanding the specificity of that sport or sport in general, as well as trying to build in certain universal principles and factors with the evolving body of jurisprudence that comes through, is something that CAS really focuses on. Now, respectfully, if we go into a state court in Kampala or a state court in Nairobi or a state court in La Paz, Bolivia, it's very unlikely that a judge, as learned as he or she may be, is going to start talking about sporting specificity and Lex Ludica. And even if they do, be very unlikely that they might be able to enforce it through their own statutes or through their own procedures. So for the sporting world, there is a reason why CAS is there. It's not appropriate. I'm not suggesting that that's what's happening. It's not appropriate that we berate it or we simply look for holes in it. Yes, there are points that can be changed, that can be improved, and can cause a lot of frustration. And I can assure you that I've felt a lot of that frustration, and I've probably lost half of my hair based on it. But at the same time, the whole system works in general. It works quite well. So it's important to recognize where CAS really fits into the system. It's also then important to recognize what else is out there. So I mentioned football, but then arguably the second most popular team sport anyway, in the world is the sport of basketball. Now, the global governing body for basketball is FIBA. However, as many of you would know, basketball has quite a peculiar situation in the world of sports where the greatest proponent of the sport of basketball is a closed franchise league in the United States of America called the NBA. So we've actually got a league, a competition, which has got more visibility, more finance, and thus more power than what is the global governing body of the entire sport. So we have this kind of situation that we've got to think about as well with regards to how the politics of the sport can be impacted. But FIBA, the global governing body of basketball, FIBA has its own private tribunal mechanism, just like FIFA does. However, an appeal from a FIBA situation would go to the Basketball Arbitral Tribunal. Any other issues that arise between players and clubs, or even agents and players, would go to the Basketball Arbitral Tribunal. Now, the Basketball Arbitral Tribunal is a lot smaller than the Court of Arbitration for Sport. It's also seated in Lausanne, in Switzerland. So its laws are underpinned by Swiss law, and it's designed to be even more quick and expeditious and cost effective than the CAS is. So I mentioned some of the challenges about CAS. Some of the good things are understanding that CAS has an appreciation for sports law and sports regulation and how these things actually work. One of the challenges is that it's quite costly. It's quite costly, and that's frankly speaking. The CAS has always pitched itself out to be a lot cheaper than commercial arbitration, which it absolutely is. For any of you that might have practiced in international arbitration, that might have gone over to the LCIA in London or the DIFC in Dubai, which is where I join you guys from today, will know that a commercial arbitration costs a shed load of money, and it's massively prohibitive to the vast majority of people that would be potentially considering it. CAS is significantly cheaper than that, but it's still expensive. It's still very expensive. It's a bit like saying a Ferrari is going to cost you $300,000. Don't worry, I'll give you a discount and give it to you for $50,000. Great discount, but it's still $50,000. So this is one of the challenges that we have had at CAS, is that it can be cost prohibitive for a number of clients, particularly from different jurisdictions, from different parts of the world, where the football economy might not be as strong as it is in England, Germany, Spain, France, Brazil, now in Saudi and in the UAE, for instance. It means that sometimes the access to justice required is not as accessible as it needs to be. And there will be a number of situations. Countries in Central Asia, Eastern Europe, the continent of Africa, and many countries in South America, aside from the big two, Brazil and Argentina, I would say, you'll often find potential cases going by the wayside simply because clubs, even federations, and certainly lay clients don't have the ability to go to CAS. Now, if we compare and contrast that briefly with the Basketball Arbitral Tribunal, the Basketball Arbitral Tribunal is designed to be cheaper and cheaper than CAS, and thus make it more effective, particularly in the world of basketball, where if we take the anomaly of the NBA aside, the basketball world is nowhere near as flush with money as when you compare it to the world of football. Football, we've got, of course, the ludicrous amounts of cash that we see in the English Premier League. And there's a big drop off from what we call the big five leagues down to many of the other leagues. but we still have an element of professionality almost everywhere around the world. Of course, there'll be arguments and discussions about how professional certain leagues and certain tournaments are, and how much money is being paid in salary and so on and so forth. But we have that element of professionality. We don't have that in basketball. So we've got, if we talk about running away from CAS and other mechanisms, in basketball, we've got the Basketball Arbitral Tribunal. And then we also have another arbitral tribunal that is growing in prominence very quickly. And I sit as an arbitrator, therefore, which is Sport Resolutions. Sport Resolutions is a UK-based arbitral body. They've been dealing with appeals and first instance matters in sport for, I think, 15 years or so. And now they're increasing their international participation. So they do quite a lot of work with the ITF in tennis. They deal with doping matters, and you're increasingly finding that a number of parties want to go to sports resolutions as opposed to other bodies. We've now also got, which I've just been honorably impaneled on, the Esports Dispute Resolution Tribunal set up by Riot Games. So we're now finding that there are new tribunals that are coming up, which are to a certain extent diluting the power of CAS. This, in addition to cases like the European Court of Justice case that was mentioned by Advocate Luganda, again, further dilute the strength of CAS. But we can't just dismiss CAS because it's still written into the statutes of the two most powerful bodies within the sporting world. And there are many other sports that still follow it, either through belief or through convenience, but they still follow it. So essentially, can you run away from CAS? Yes, you can, but there are very limited routes for you to be able to do so. So Brian, I don't know if I've answered your question. I hope I have answered your question, and I hope I've put it forward in a clear and cogent manner for all of those that are participating today. Indeed, I understand that I was supposed to assist all of the participants with something totally different, but I've rambled on about one question that you put to me right at the start for the last half an hour or so. So I don't even know if there's too much time to discuss anything else. But of course, I'm happy to take any follow-up questions or to move on to some of the points that I was seeking to discuss with regards to the athlete's perspective in sports arbitration. I'm completely at the disposal of the Uganda Law Society.
Thank you so much, Dev. That was very insightful. I don't know whether we have, help me scroll. Do we have a question there? Any question? Yes, Dev, you can proceed with any other related area for the benefit of the Uganda Law Society members, in particular the sports law practitioners. Over to you.
Well, thank you, Brian. Well, again, mindful of time for myself to a certain extent, that I've got to put my tie and my blazer on, and I need to get to a board meeting very shortly. And also for yourselves, I'm sure that there will be a lot that you guys need to take in today, and you've still got some preeminent panelists to speak. I can see my dear friend Dennis is also on the call. So I'm sure that you'll be learning a lot from him very shortly. But just moving forward, and I'll try and keep it as brief as possible with regards to the athlete's perspective in relation to sports arbitration. Now, we've spoken about sports arbitration or in a very general sense. And I'm sure that some of you who are on the call today will know all about what I've discussed. And in that sense, I apologize for repetition. some of you might not know about what we've discussed. And it may be that I've discussed it in a very truncated way. So in that sense, I apologize that I've not gone into enough detail. And of course, if you've got further follow-up questions, please get in touch with Brian and the ULS, and I'm sure that they'll put your questions forward to me, and I'll do my best to answer all of them accordingly. But if we just narrow down on one specific component of that for a moment, which is the athlete's perspective. Now, we've already touched upon, and my learned friend, Advocate Lukanda, was talking about it earlier, which led me to put up the citation for the Mutu and Pechstein case, is the right to a fair hearing. Now, we do have challenges like this. There are legal considerations. But I'm going to gloss over that for a moment. And I'm going to focus on the practicality. Now, speaking as a legal practitioner, and it may be that some of you will agree with me, it may be that some of you won't agree with me. And the irony is that some of you who won't agree with me will probably fall into exactly the point that I'm going to raise now. As legal practitioners, it's very easy for us to get bogged down with the law. Now, that sounds fairly self-evident because that's what we train for years to do, to understand the law, to understand the regulation, to understand the procedures, to understand the technicalities. And it's only our job to do that. So that's absolutely spot on. Nothing wrong with this. But this always needs to be matched, or it always needs to be married with the why. What is the why of the athlete? What is the reason for the athlete challenging a particular situation or contesting an alleged infraction or whatever else it might be? We have to be practical to focus on what the athlete wants to achieve at that time. And we've also got to be able to consider the real life time and the real life cost to the athlete. Now, I mentioned it briefly when I was rambling on about CAS a few moments ago. The cost to the athlete can be heavy, it can be expensive, and in some instances, it can be prohibitive from them even accessing justice in the first place. Now, we've been in numerous situations where there is a technical legal case, but when we then step back and focus on the entire picture, the simple reality is it's not practicable and it's not purposeful for our client partner to take the case forward, whether it's an individual, sometimes even in the case of institutions. We've got a matter, in fact, speaking even more off the cuff, we've got a matter right now in our offices where club versus player dispute, financial dispute, just to give you guys a quick picture in your mind, financial dispute between a football club and a football player. The matter went to FIFA because there was an international element. The club, the player was a foreign player in the jurisdiction of the club. So it went to FIFA. And in essence, we got a great decision for the club. And the club was happy, really, really happy. The claim was of a significant six-figure sum in dollars, US dollars. And we managed to mitigate that claim down to a lower end five-figure sum. So the club was extremely happy with the result. At the same time, the decision being rendered has led to there being a legal technicality in that decision, which we read in the decision, we found, we explained to our client that we could take this forward and we could win. There's always a risk, as you all know, that there's no such thing as open goal in any court case around the world. there's always an element of risk. There's always a litigation risk. It just depends on how big that litigation risk is. But we looked at it and said there's a reasonable to good, maybe even very good prospect of success here. Client really wanted to move forward, really wanted to move forward. But then when we look at the costs of the CAS case, it's not going to make sense for them. So there we have that balance. We have that issue that we've got to consider as legal counsel. Advocate Luganda was talking just at the end of his presentation saying we are the arms, the eyes, the ears, the legs, we're everything to the client. We are the ones that have to provide guidance, provide counsel, and we are the ones that have to then go and do the job to a great extent as well. And in that sense, it's important to ensure that despite our years and years of legal training and our skills being honed on the coalface in a tribunal or in a library reading books, it's important to suppress our own personal skills to a certain extent and just step back and say, actually, this doesn't make sense. This doesn't make sense for you. And to reassure the clients from that perspective. Because ultimately, what is their why? Their why is that they want to end this case as quickly as possible and as cheaply as possible. And I gave you that example completely off the cuff, but I gave you that example to reiterate. It's always important to understand what the why of the athlete is. Sometimes the why of the athlete is to fight as hard as possible, and they don't care how long it's going to take, like with Adrian Motu. Adrian Motu's case that went to the European Court of Human Rights and was finally decided in 2018 started off in 2004. So we're talking 14 years for that litigation journey to go from England to FIFA, back then to Switzerland, to CAS, and then to the European courts and going through that European court mechanism. Some people just want to fight. So that was his why. Other people don't want to do that because they're thinking of the competition. If we look at a disciplinary situation which might impact a certain amount of games or matches or fights or whatever it is that we're dealing with, a disciplinary situation that impacts that, frankly, you don't want to spend too much time or money on it. There's always that balance that needs to be considered. The amount of technical legal cases that we get coming into our offices or that we even see in the periphery, okay, that's wrong. That's not fully complying with this procedure or that regulation. But the reality is, if the sanction is a 1-match suspension or a 3-match suspension, why would the player, why would the player's agent, why would the club advise that we spend several thousand euros, dollars, pounds, whatever it might be, on bringing lawyers on, fighting something, also considering the perspective or the perception, making that person look bad, like they're just a bad apple, because we're dealing with a fraternity here. The football world globally is a fraternity where everyone is supposed to stay in good terms with each other. Why would they risk doing all of that for sake of a match or two? Now, of course, if it was the Champions League final, it's a different story, or the World Cup final, it's a totally different story. But in general league competition, you wouldn't do that. You would balance up the real life time and cost to the athlete and whether it's worth it at all. Now, this is something that's not going to be unfamiliar to many of you that don't practice in sports law, because you have to factor these things in with lay clients and corporate clients as well, but to a different extent. Because usually, outside of the sports world, the time sensitivity will be fundamentally different. And in many sectors in the law, the time sensitivity that you've got is only based on a statute of limitation. Sometimes you don't have other time sensitivities to take into consideration. Sometimes you do, but many times you don't. In sports, however, it's a totally different story. If we're dealing with a disciplinary matter, sometimes the matter needs to be dealt with in hours because it's going to impact the next round of games that will take place on the Wednesday or the next round of games that takes place on the Saturday. And that's in normal national competition. If it's a condensed competition like the World Cup or like the Olympic Games, it needs to be dealt with in hours because the next stage of the competition is taking place tomorrow or later on tonight. In addition to that, you've got heightened public scrutiny. Everyone's eyes around the world, or at the very least, even if we're talking about national level, everyone's eyes around the country will be watching this competition. So you want to make sure that you're doing something that, even if there is a technical legality that could be argued successfully, you don't want to do something that makes your client look like an idiot in the eyes of the public, in the eyes of his or her fraternity, just because you've got a legal technicality that you can win on. So that's why I say it's important to almost suppress the desire to get bogged down in the law and the regulation and the technicalities. The most important thing from the athlete's perspective is the why, and understanding how you can then navigate using your legal skills, the procedural rules, the jurisprudence, the legality, in order to achieve that why. And if you cannot fully achieve that why, then it's important to be stealthy and step back rather than sometimes push it through, because pushing it through, unless the client really wants to fight and has got time on their hands, pushing it through can often cost them a lot more, both in finance and in terms of the time lost and their reputational impact that they'll suffer within what is still a very closed industry where everyone knows everyone. The last thing you want to end up doing, unless it's really necessary, is to look like an outlier. So these are things that we've got to consider in the sports world, which sometimes you don't really have to worry about in the world outside of sports. I don't know if anyone's got any questions at the moment. Of course, if you do, I'll hang around and try and address them quickly. If you don't, then please do have a think about some of the things we've discussed. Put those questions forward to Brian and the ULS, and I'll hopefully receive them thereafter, and I'll address all of your questions as best as I possibly can. But Brian, thank you very much for your very kind invitation. Thank you to the Uganda Law Society for having me back to support you, and I do hope that everyone here has been able to take something away from my monologue over the last 40 minutes or so, and I do hope that you enjoy the rest of your day. You've got Dennis coming up. You've got great speakers coming up. You've already had great speakers. Make the most of it. And I hope that you maximize your opportunities and that I see you in the sports world very soon.
Wow, it's amazing. Thanks, Dave. Maybe before you go, do you have a minute or two for just two questions?
Please.
One, kindly throw more light on the nature of sports disputes. Let me just give a brief background. You have different sports disputes. There are on-field disagreements. There is a code that governs a given sports discipline. A player is summoned before either the FA or the regulator dispute mechanism chambers. He's not satisfied with the decision, or you have another arrangement that involves a severe tortious action. On field, I sustained severe injuries as a result of your tackle, and that tackle or that injury or your tortious action is protected under sports law or the laws of the game. I'm not supposed to take you to civil courts to sue for negligence or a total of battle and all that. The lawyer on this call is concerned about where the specificity of the game of sport ring fences the avenues of resolving such cases. If you're given a red card, you're banned for 8 matches. Well, I may have insurance, but I think the law should punish you the more such that a strong message is sent outside there. So what are the nature, just draw a line between the nature of those disputes that are supposed to go before sports arbitration, or even when I'm a sports sponsor, I have an arrangement with you, there is breach of contract, you've not performed your arrangement. Do I pursue you under normal courts of law because this is a contractual arrangement? I'm not a sports person. Mine is just to invest. Or I'm also covered under the sports arbitration legal regime. Then maybe the last is I'm meant to understand that CAS, as one board of dispute resolution mode, it has tiers. It has, I think, the ad hoc, it has several structures up to the appeals, the final appellate division. Is CAS bound by the doctrine of precedent? Then lastly, you've talked about the cost of arbitration. Let me call it the cost of international arbitration. That is in particular CAS. Don't you think that this is the high time we had our African CAS? Do you think it's something we can advocate for to minimize on the... Because there are many people who want to pursue that approach, but it's costly. Over to you, Dev.
Thank you, Brian. Good questions, and I'll try and address each of them in turn very quickly. So first, you're spot on. We've got situations where matters arise in game that can be dealt with by the local disciplinary regulations or the competition disciplinary regulations. So essentially, the football regulator globally is FIFA. And as we've already mentioned, FIFA has got 211 member associations, of which one is FIFA. So FIFA would have its own statutes, and of course, no doubt, my dear friend Dennis Lukambi will be able to tell you about this a lot more than I. FIFA will have its own statutes, just like any other member association would have. And then you'd have the rules of the competition organizer. So the competition organizer would be the Uganda Premier League, or it'd be the English Premier League, or it'd be La Liga or Serie A or whatever. Now, these are not governing bodies themselves per se, but they've got their general rules. If you get, as you said, Brian, if you get a red card and the red card is for X offense, then you're going to have a 3-match ban or whatever else it might be. So essentially, if we're talking about generally looking at it from a disciplinary perspective, with local level, and if there is a separate competition organizer through the competition organizer's rules, like when we have continental competition with CAF, for instance, then you'd have the CAF competition rules, or you'd have the UEFA rules for the Champions League and the Europa League and the Conference League. It wouldn't be if Manchester City is taking part in the European Champions League and something happens in a game between City and Leipzig, let's say, the English FA is not going to get involved, or the English Premier League is not going to get involved. It'll be the competition rules. So there'll be certain situations in that sense. But as you rightly pointed out, if we have a tortious situation like an injury that takes place during a game, and it is deemed that injury is something that has happened due to an action that is not reasonably expected within the course of football, then that can still go to the national courts. And we've had a couple of instances like that, fairly prominent instances even in England and Wales, where a player has been on the receiving end of a tackle. The tackle has been legally determined, let's say, as being an extra football tackle, something that you don't voluntarily sign up to. You know, we've got waivers, and we've got the assumption of voluntary risk, that when you go onto the field of play in football, you expect to be slide tackled. You might expect to have a clash of heads or hit an elbow on the way up if you're challenging for an air ball from a corner. If you go onto the field of play in rugby, you expect to be crunched. If you go into the boxing ring, you expect to be jabbed and crossed in the face. This is normal. There isn't any transference, though. If you're playing basketball, you don't expect to be thrown a left hook. If you're playing tennis, you don't expect someone to slide tackle you, and so on and so forth. There's a reasonable assumption with regards to what takes place on a field of play. And if an action takes place that results in an injury, where that action is something that's not reasonably expected, or can arguably deem not to be reasonably expected within the field of play, that can still go to the national courts. And we do still see that kind of thing happening. The second question, Brian, if I'm not mistaken, was to do with costs, CAS costs. Now, CAS costs can be prohibitive. We then have to consider this a little further, because we've got to understand the amount of money involved and then why it's there. Now, CAS arbitrators themselves don't get paid comparatively a hell of a lot of money for the work that they're doing. It is still a high global level expertise, a niche expertise that they're applying, and they're doing at a comparatively low cost when we look at, again, commercial arbitration and things like that. And by the time you get a panel of 3 arbitrators, which you don't always have, you don't have in most instances, to be fair, but by the time you get a panel of 3 arbitrators and you have to have a hearing in Lausanne, the costs can be extensive. The costs can be narrowed down quite a lot in many instances where a sole arbitrator is requested, and furthermore, if the hearing is done online. That knocks off a significant chunk, but you're still talking about, you know, putting in, as an appellant, putting in a deposit of 20 or 25,000 Swiss francs, which is probably like a more or less one-to-one, so $25,000 as a deposit, which part of it can be returned to you depending on how much of that amount has been used by the CAS, and also depending on whether the appellant wins the case in the end and makes an argument on costs as well. So doing all of that can be prohibitive. And then doing all of that for something that, A, you might not win, and then from a general legal perspective, something that doesn't set precedent, just to quickly highlight to you, every case is determined on its own merits and will be deemed to be persuasive for a future CAS panel, but it's not precedent setting in any way, shape, or form. It's enforceable because CAS is recognized as a foreign arbitral body by the New York Convention of 1958. Of the signatories to the New York Convention of 58, I think there are about 165 of them, have the ability to take a CAS decision and to enforce that CAS decision through their own local courts if they need to. But it's not precedent setting. Finally, your question with regards to the African CAS, good question. And I think, Brian, you know very well, it's something we've been discussing for several years at high levels as well. And look, personally, I love the idea of having an African CAS, not necessarily an African branch of CAS or using the CAS brand. That could be a consideration, but I love the idea of having a more localized dispute resolution mechanism in play. But as with many things, the idea is a wonderful one. When you look at it blue sky, as to how the reality would take place is a different story. There's a lot of political maneuvering that would have to be done first. Then we would have to see where the seat of the body, of course, would be, and then in order to truly reflect the continent of Africa and the 54 nations, we would need to take into account how everyone can have fully equal access and representation, and where we've got a number of different cultures within each country, a number of different languages within each country, that in itself is immediately a challenge. So we need to think about what the actual languages would be. And if we look at the commonalities, we can loosely say English for the Anglophone countries, French for the Francophone countries, and Arabic for the Zone 1 countries. They could, in theory, be the official languages of the CAS, but I'm sure that there'll be tribes, there'll be communities, and there'll be certain nations themselves amongst the 54 that would probably argue for something else as well. So I think there's a lot of maneuvering and discussion that needs to be had first. But as an idea, I absolutely love the idea of a localized dispute resolution mechanism, and would be 100% behind it. But we've been talking about this, I think, since 2016, and I haven't seen too much development yet. So let's see what happens.
Well, this is so great. Dev, you will agree with me that I'm heavily indebted to you, first of all. I'm proudly associated that I went through your hands, but also you've always been there whenever we call you upon to share with members of Uganda Law Society. You're such a kind guy. Thank you so much. I'm sure very soon we shall be linking up on so many trainings, and Uganda Law Society members will reach out to you in their individual capacities to seek for further guidance and training. As you leave this call, I'm sure you have another meeting. Yesterday we had a discussion. But one members of Uganda Law Society, the sports lawyers, one of them had a question. It was a general question whether employment matters are subject to arbitration. The question was further narrowed down to sports arbitration. You have a manager of a given club, sports club, a player himself, his contract is terminated, and he wants to enforce their rights. Should that person go through the normal courts? Here in Uganda, we have the industrial court, which handles labor disputes. Then colleagues were of the view that it matters not whether it's an employment matter, for as long as the arrangement is between a sports federation, a sports club, and an athlete. To that regard, the person should go to sports arbitration chamber if there is any. So, but your answer has thrown more light. I'm sure the lawyer who raised that interesting question is on this call and has gotten the answer. Thank you so much, Dave, for sharing your international perspective. It's very helpful to us, especially that we have a new law that is ushering in sports arbitration. I'm sure later we shall have a specialized training on arbitration. We have arbitrators in Uganda. So many of the lawyers on the call are going to be listed as those arbitrators. But also, in addition to the generalized arbitration, experts like you who have had this, you have the hands-on training, your expertise is very, very, very helpful to the members of Uganda Law Society. Thank you so much, and all the best.
Thanks a lot, Brian. All the best, guys.
Thank you. Members of Uganda Law Society, we're now nearing the end of our discussion. We're going into the panel discussion. We're joined by Atuhaire Patience Marcella. She's on the call. Then later we shall have Magom Ivan. So Patience is going to take us through the topic Dennis discussed, but she's now going to go into the nitty-gritties of it. I'll do an example of Ham Stadium. We've had so many questions. I think it was early this year. He named the Nachivable Stadium as Ham, if I'm not mistaken. Many lawyers and fans came up questioning the criteria Ham used to name Nachivable Stadium as Ham. We've had we have Nambole. It's called Mandela. There's so many football cases here. We've had MTN Arena, quite many. So she will take us through some of those aspects, like stadium naming rights, what is it, who benefits. Then we have those traditional names that are accustomed to the stadiums. The Nachivubo War Memorial Stadium. Now it's Ham Stadium. Shall we ever witness Nambole, or rather Mandela National Stadium, changing to probably Philip Omoni Stadium, to Ivan Magomu Stadium, to Barclay, rather to Absa Stadium? So she will take us through. So Patience, you're most welcome. Briefly about Patience. Patience is a sports lawyer. She's a member of the FUFA Legal Committee. She's also a registrar of titles at the Ministry of Lands based in Lira. Patience is an EXCO member of UIFA. Patience is also an assistant lecturer at Law Development Center, Lira campus. She also happens to be the former registrar at Uganda Registration Services Bureau. She has a wealth of experience in sports practice. She's one of the first cohort that was trained. I was trained with her by Dave and the Uganda Olympic Committee in sports law in 2019, alongside other members and like the likes of. So you're most welcome, Patience. Over to you.
Thank you, Brian. I'm not very sure how much my colleague has covered on commercialization of sports. As you have introduced, I am a member of Uganda Youth Football Association, and basically that is an association that deals with sports academies. So you'll forgive me if I venture into sports academies, because that's an area that very few people have paid attention to, yet it's one of the new upcoming areas where we should put our attention. My aim or what I concentrate on is usually how to commercialize these sports ventures. And I needed us to look at, yes, Brian we have looked at the rights that everyone has in sports, either the athletes, the federation, the companies. But then academies are usually not paid attention to, because most of these are charitable ventures. However, in Uganda, we realize that many people are venturing into this area and they expect to make money out of it. So briefly, I'll touch on two academies and then I go to stadium. Though in stadiums, there's not much to say. But for academies, what I needed to look at as lawyers, how do we enter into this area? We have had very few lawyers engaging with academies, and I wanted us to maybe to open a road for us to engage in them, either administrative-wise, legally, or by even owning academies. As academies or as sports entities, I want to look at what we call branding. Branding is the biggest way that we are making money in the sports world. And even what I would have talked about on stadia is related to branding. So branding in academies, usually, we start with logo. Do you have a logo? Do you have a motto? Do you have maybe like an anthem? When we have that, then how do we protect it? Then we go into intellectual property. Do you have copyright? Do you have trademark? Have you registered those intellectual properties? And then after you register, how do you market what you have registered? How is your engagement with the fans? Do you have a website? Do you have social media? So we promote this engagement as a way of building our brands. Once your brand is solid, then we look at innovation. How much more can you innovate your product? Can you venture into other areas that are affiliated to the sports you're offering? And once you have packaged your innovation very well, then we look at now, how do you commercialize it? So the commercialization starts with getting sponsors. When you're obtaining sponsors, you need to have what you're offering to them and what benefits they are going to get out of that offer. Also, we have what we call broadcasting rights. I am very sure that is something that we have all been talking about. But for Uganda, we need to develop this issue of broadcasting rights, not only looking at the main media, but also looking at social media, live streaming, esports. How much more can we venture into this area and make some money out of it? Furthermore, on that issue of commercialization, we need to look at merchandise. This is an area that even FUFA itself is developing. We have Uganda Cranes t-shirts, and the way the merchandise is being sold is still, let me say, backward, for lack of a better word. You go to Owino, you go to Arua Park, and every shop is selling with or without a license. So this is an area that we also need to develop on how we can license the people who are selling this merchandise for us to make some money out of this merchandise that is being made. Because you might make your jersey, you've created your brand, you create your jersey, and then someone in Owino or Arua Park or another place just copies it, goes to China, imports a whole container full of the merchandise and goes ahead to sell it. So as the legal community, these are some of the areas we need to look at. And lastly, because most of us are advising clients on these issues, we need to look at now, what is our input as lawyers in this? Because most of what we are talking about is commercial. How about the legal aspect? When do we come in? The structuring, what is our offer package to the sports community as lawyers? So I think even after this engagement, we need to think deeply on what do we offer the sports community as lawyers? How do we position ourselves as lawyers to show that we can add value to the sports community, apart from the usual arbitration, representing them in court, which now is no longer viable? What further can we offer to the sports community as lawyers? So I thank you. That was briefly what I'm going to talk about. I don't know whether I should venture into the stadium right away. I seek for guidance on this.
If you had any other contribution, you can go to that. Then later you conclude with stadium naming rights.
So from the audience, should we talk more about commercialization of sports, or this is a topic you feel we have sufficiently covered? Do you think there's anything more I need to talk about on commercialization of sports? I would like that input before I go further. So on the issue of stadium, a stadium is part of the branding of a club, a company, a country.
Maybe in response to your question, let me just throw a question such that you cover other areas which Dennis didn't delve into so much in relation to commercialization. Is that fine? Then you go to stadium naming. Dennis gave us an extensive overview of commercialization in sports industry, in particular in football. There are so many cases where a fan, actually it's no longer a fan, we're no longer fans, we're consumers. Because when you are seen as fans, we divorce the commercialization component from the game. So now fans are no longer fans, are consumers. They are so obsessed with the sports products. So a consumer will don a jersey of a given club, national team, and for FIFA they have faced so many challenges of enforcing counterfeits. Now, starting from the contractual arrangement, luckily an entity like FIFA, Dennis represents, has a commercial department or entity that runs or that manages its commercial products. Here you have a team like, which example can I give? Or you have a federation like Uganda Rugby Union. They have their own sports products. They have products that they have to put on their jerseys. In the process, they have a competition and they're supposed to commercialize their sports merchandise. The question is around the rights that are given to a third party. Uganda Rugby Union will approach you, Marcella, and they will tell you, we want you to sell our sports merchandise. A club like Vipers will approach you, will tell you, every game we have at our stadium, you will be responsible for jerseys, capes, scarves, name them. Now, with the fluidity of our market, how can you advise your client who has gotten an exclusive distributorship rights to distribute sports merchandise for Uganda Cranes at Nambole whenever we have an international competition, or sports merchandise for Uganda Rugby Union games, or a given club, whereby I have invested my money as a distributor. I am the authorized distributor of your kits or your sports merchandise. But downtown, in Owino, Katwe, name them, even some of those arcades, you're going to find replicas. Not replicas in legal sense, but what we call fake products. Is there a way you can best advise a sports federation, a sports club, and a sports merchandise distributor on how best they can safeguard their rights and also the clauses in such agreements in light of the flooded market where you can't have exclusive rights to distribute a sports product? Before you know it, the fake might end up being the genuine than your genuine product. So we realize that has been the most sensitive, and FUFA has experienced that a lot. I'm not aware of other sports disciplines, but they have either failed to get business partners to perform that role, plus other entities, because I'll give an example as I wind up on this. There was an arrangement where Adidas wanted to enter into the Uganda sports industry some time back. Their problem was, yes, I can be your kit sponsor, you are FUBA, you are this. The problem I have is there's no guarantee that if I invest, let's say 1 billion UG shillings in this sports federation, and the national team should put on their jerseys with Adidas, what I get in return, it's sales. So the more Federation of Uganda Basketball Association sells its jerseys, then on my side as Adidas, I have a percentage. So I get more money, and in turn, I'll recoup my 1 billion and I'll get the profits. So if I invest 1 billion in FUFA or Uganda Cranes, and they're going to don Uganda Cranes jerseys with Adidas as the kit manufacturer or sponsor, before you know it, all the Uganda Cranes kits, I'll find many in Chikubo, in Owino. Then the authorized distributor and seller of those jerseys will have made losses, and before you know it, they will just run out from the market. So in light of the fluidity of our market, how best can you advise sports federations, merchandise agents to safeguard their rights and in the long run maximize on profits? Thank you.
Thank you, Brian. Incidentally, intellectual property is one of the areas I'm very, very passionate about. And when I was in legal practice, I and some lawyers, we formed an association called Stop Counterfeits Uganda. And our focus was on how to fight these companies that are doing counterfeit products. The association is still active, though I am not actually active in it. But one of the concerns we were looking at was how do you manage these small scale counterfeit groups, because they are actually very small scale. And one of the ideas we had looked at is engagement with the associations. Because when you look at these small people, they have their associations. You have the likes of Kasita. Kasita is a bit bigger, but the people who import these jerseys don't do it on their own. There is a larger group that is importing and then distributing. So what would need is engagement with the larger groups. Then it trickles down to the smaller people on the street. Number one, enforcement is where we had a challenge. I think we had engagement with URSB. By then, URSB was venturing into IP enforcement, and they had a field team. I don't know how active that is right now. I think the efforts have cooled down a bit, but then they had a field team that would work with Uganda Police, and they would enforce any counterfeit, any idea that there's a counterfeit, they would be on ground. Now our issue was these products are imported and cleared. So the challenge is how to enforce with a larger group, maybe have agreements, maybe make concessions, maybe license to them. And I still think this is possible because most of these people are operating on ignorance. They do not know that what they are doing is illegal. For example, if their goods are to be cleared, on what basis is URA clearing these goods? Because these goods are usually manufactured from China. And I think on importing these goods, they declare what they are bringing into the country. And then these goods are cleared, yet clearly they are counterfeit goods. So we need to have engagement with all the agencies who are involved in this process. And one of the things we need is to have a clear legal framework where URA is educated, URSB is educated, the traders are educated, everyone knows that this is illegal, we can't just do it. Or if someone is to operate, where is their license? Who has authorized them to sell this type of goods? If I'm going to sell sports goods before I obtain a license, and all these shops actually have licenses from both KCCA, from they pay their tax to URA, before they pay all these dues, do they have that clearance? Do they have a license to sell these goods? So I think we need to look at how to engage with the relevant actors to be able to enforce, because on our own, it's hard to do this enforcement. But when you unite with many different agencies, including police, including URA, I think this can be easily done. Another challenge we had was on registration. We have a low level of registration of these logos, trademarks, and copyrights. Most clubs and academies are using logos which are not protected. Now, how do you help someone who is not registered? How do you protect what is not registered? So the first step would be to encourage registration, and then we can see how to protect. I submit.
Thank you so much. Yeah, that's very sufficient. Maybe still on that, my takeaway from that is that there's need to corroborate between these sports federations and other relevant stakeholders. My experience with some stakeholders like URA, in as far as intellectual property enforcement is concerned, is that they are very reluctant. We've always, from our side, as Marx advocates, we've always tried to engage Uganda Revenue Authority on behalf of our clients. You realize that someone can import fake products, counterfeits, or even genuine products, but bearing the trademarks of another proprietor. Now, we tried to move Uganda Revenue Authority to develop a recorder system. That recorder system helps the proprietor of a trademark that deals with specific goods to monitor and arrest a possible situation of infringement and counterfeit at the entry point. Because once those goods enter the market, it is hard to monitor and enforce your IP rights, save for if it's a big entity. So the move and the proposal was, URA, can you help us? Let's get in touch with URSB. Let's have a recorder system at URA that if goods are being imported, you can easily flag goods that are bearing trademarks of a given proprietor, and the person importing must adduce proof of ownership of a trademark on their goods, or at least any other contractual document, which could be probably an assignment, deed, among others. Interestingly, URA told us that, well, my role is to collect taxes. I'm not here to enforce IP. Whether it's fake or what, any goods that enter Uganda, I'm ready to tax. The issue of whether it has fake, for as long as the goods are permitted to be in Uganda under the law, what they bear, that is none of my business. So, but I get of late, they are corroborating, they are forthcoming, they are willing, they understood, though it's not a structured or formal arrangement, that they have a policy. But that, in my view, I concur with you that would be one of the best ways to curb counterfeits and IP infringement. The other is, you've talked about Casita. I like that arrangement. The idea of, for example, URA brought an idea where they collaborated with the KCCA. For you to operate in Kampala, even if you have a saloon, you have a Rolex store, you must have a TIN number. Now, KCCA cannot give you an operating license without a TIN number. When you talk about a TIN number, they are sending you to another regulator. So, before they allow you to operate, you must have a requirement of another regulator. Just like us lawyers, the compliance as far as NSSF is concerned. So that collaboration between one sector and other regulators can help to mitigate. It may not rule out all those, but at least can mitigate. So federations like FUFA, FUBA, Uganda Rugby Union, and any other, or even different, actually, I don't want to talk about clubs, but those clubs under their federations, I think it would be a good move. You enter into memorandums of understanding with some of these entities, URSB, UNBS, URA, and all you need is to flag such that these counterfeits are detected, because people who print these things, they take them to other jurisdictions in China. Then you find a consignment of jerseys of vipers, they are coming in, but the person is not the proprietor of the rights in those jerseys. So I think collaboration would be the best, in addition to sensitization of not only us, the lawyers, but the muntu wawansi in Chikubo, in Owino, those are the ones that are a potential threat to the rights of different entities. Patience, any other you wanted to share on stadium naming rights? Then we go to our last presenter, or Ivan, for our panel discussion. Then we shall close it. We'll continue to thank members of Uganda Law Society who are still on the call. In a few minutes, we shall be winding up. You may continue, Patience.
Thank you. Another issue that I had skipped is branding through fan engagement. Now for like Jose, if we have an idea of, you get a few agents, you promote them, maybe let's say FUFA has its agents who are going to sell its jerseys, and it clearly has a list of authorized people to sell jerseys. Now, if it declares that if you don't buy from these people, whatever you're buying is counterfeit, this would also work for people to actually look for the original people and know that I'm buying an original product at whatever price it is. There's that pride of whatever I'm buying is original and it's not China made. So I think that's also an avenue we can look at strengthening our original products. Now, on the issue of stadium, I put it under a broader issue of branding. Why stadiums are looked at as something that is marketable. Number one, we have broadcast exposure. We've all watched games, and before they enter, you'll see Allianz Arena on big screen, Mandela National Stadium on big screen. So even people who are going on foot, they want to take pictures in front of the stadium and show everyone, yes, I'm now on ground, I'm on this place. So it's that exposure, that broadcast exposure, that whatever name is on the stadium, it will appear in many photos, it will be a marketing tool. And then it also reduces on the money you spend on media, in exposure and all that. It's also part of signage. If you have a logo and you put it on the name, that logo will move faster than if it's not on the name. So we look at this naming as a way of exposing, of marketing, of branding, and the many benefits that you can get from it. Now, a stadium doesn't restrict itself to just a physical bit. If we put on maybe jerseys, you have, let's say, an affiliated hotel, you have affiliated products to the stadium, all those, you can market them under that name. Why people these days are moving to naming the stadia is that, number one, they look at the property. What prestige is associated with a property? Let me say, Mandela National Stadium, it has the nationalistic element, the African element. There's a prestige that someone says, yes, by me appearing at the stadium, I'm taking a picture, I am standing for Africa. So there's that prestige that we look at. Then we look at the audience that is coming in. What value are they adding to the sports? What are the benefits? If we take a group photo in front of Mandela National Stadium, does it make any difference? Then we look at the opportunities that are available for those who go for the games. You realize how many traders and how many traders are outside the stadium and how many are actually allowed inside the stadium. And then intellectual property protection. So if that logo or name can be protected, can be registered, and then you protect it, for someone to use it, they need a license and all that, then you get value commercially out of that naming. Why now we are moving from generic names to specific names is that people have now found a branding opportunity in stadia. And outside Uganda, you realize sponsors are taking up names of stadia and entering into agreements with the clubs or academies and then paying in much money. As we can see in the shirts, how you sponsor t-shirts, now we have sponsorship for stadia, and then the club or country or academy is going to gain financial benefits or other benefits from giving away that right to naming and then gaining that benefit. So as a commercial venture, I think it's a very, very lucrative venture, except that we need to now put a regulation, which names would be acceptable, which names would be, offensive, because commercially, sometimes if you don't put a limit, they will include names that could be offensive to certain classes of people. So we need to have more regulation before we start moving into the stadium naming venture. Like, we need to have an acceptability threshold. And then if we say, let's say, Ham Stadium, will we let it stand as Ham Stadium, or we'll need another name included in between Ham and Stadium? So I think this is a field that we need to have more regulation on. I don't know if I still have enough time, but I beg to stop here. And if there are any questions, I'll answer them one by one. Thank you.
Thank you so much, Marcella. I think the questions will be shared via the chat. I just had one, but it's about royalty, brand royalty. If I've come with a counterfeit jersey to watch a game, a rugby game, basketball game, and indeed it's on face of it, it's a counterfeit jersey, but I'm trying to express loyalty to my team. I don't know whether we have a legal regime. Maybe you may advise the sports lawyers and the business sports administrators on this call. In such cases, I'll later go to Dennis on this, but I just want to pick your mind. In such cases, do they arrest the fans with fake products as evidence? Or now that is the task of the owner of the genuine products to pursue the source? But genuinely, you enter a football tournament or game, 90% they are putting on fake or counterfeits. Mind you, there is a business arm of your federation or your club that manufactures genuine. So in such a situation, how do you recommend organizers of such events to take action? Or we just let the fans be? They have come to enjoy. In one jurisdiction, they were arrested with fake products. Over to you. Then I'll probably invite in Dennis. I have Alex on one question to do with stadium naming rights.
Thank you. What I need us to take note is that sports is something that is associated with fake. And most of this in Uganda is 3/4 true, because when you enter the stadium, 3/4 of the people are wearing fake jerseys, and you can't even tell the original from the fake. There's lack of knowledge, there's lack of guidance on where you can get the original and where you should not support the counterfeit. So you can't blame the end user who has chosen to associate. And maybe if they had the knowledge that this is where I get the original, they would have gone to that way. Then there's also something we call ticketing rights. Someone has bought a ticket to attend a game. There are certain rights that are associated to that ticket that you need to also defend before you decide to maybe arrest them on something else that they have committed. So I think Alex would also look at ticketing rights, what rights does someone who has bought a ticket have when they enter a stadium. But I think in this case, we need to focus our efforts on the suppliers, the manufacturers, and the people who are perpetuating the illegality, rather than the end consumer who might be ignorant in this game. I thank you.
Wonderful. Thank you so much. Alex, are you there? In 1 minute? Alex Luganda? He's the Director Legal Vipers. I had a question for him. Maybe if he's listening, he can just type. I'm sure he's attending. In a given year, I saw Vipers stadium name is, I think, St. Mary's Stadium. But in the same year, on different intervals, I witnessed the change of names. In 1 month, it was St. Mary's. Then later, I saw Hima. I think it was Hima something. It had a logo, a name of Hima. Then it went back to St. Mary's. I thought that would have been the best person to throw more light on that. Anyway, he will text his response on that. Our next speaker is set and ready. I think I'll just use a few seconds to have him set up here, and then we'll be good to go. So just give us a few seconds and welcome our next speaker. He's attending with us live here. So we shall be having Mr. Ivan Magom. He's going to have to share with us his experiences as a sports person and athlete, at the same time as a lawyer. So Mr. Luganda took us through the disciplinary proceedings and hinted briefly on the rights of athletes. So Ivan is going to now to share his experiences. He's an athlete who will tell us whether actually these persons have rights in reality. Ivan Magom is a sports lawyer. I happen to have attended that first sports law lengthy training where Dave trained us. I attended it with Ivan Magom. Ivan Magom is a director at Mashiriki Sports and Entertainment Entity or Advisory. He's also a member of the Uganda Olympic Committee, Legal Committee. Ivan has taken part in the Sevens Rugby World Cup and Commonwealth Games. Ivan also represents Uganda Rugby Cranes from junior level to senior level, winning the 2023 Victoria Cup and securing a place in the next year's World Cup qualifiers, having led Uganda to the 5th place. Ivan is also a serious legal practitioner in this industry. He's also a club captain of Stanbic Black Pirates. And with that, I think we have the best person to share with us the experiences of a sports person, an athlete, but also where he was as a sports lawyer. Ivan, you're most welcome. We still have our members of Uganda Law Society waiting to hear from you. You had the speakers. I want you to go straight to, let's start with the rights of athletes. You are an active member in the rugby sport, and a lot has happened to your fellow sports persons, which has not spared you. So in general, take us through the rights of your colleagues, inclusive of yourself, whether actually it's the reality. We may talk about them. Alex took us through those rights that ought to be there. But now, report to the members of Uganda Law Society, such that if we have a legal aid, if they are to come and help members, then we'll be good to go. So, Ivan, over to you in the remaining minutes. We continue to thank those who are still on the call. Thank you.
Thank you very much, Mr. Kajubi. It's always a pleasure. I'd like to thank the ULS for this amazing opportunity to come here and discuss Lex Sportiva, something we know as the sports law. Thank you very much. I would also not continue my not thanking our revolutionary president, Senior Counsel Isaac Semakade, for implementing your manifesto without fear or favor of decolonization, demilitarization, and digital transformation for our society. Today is an important day. for athletes in Uganda. I stand here, I come here as the chosen few in this country who have been able to play the sport and also go through school, finish the bar, and remain competitive. Rights of athletes. Before being an athlete, I am a Ugandan citizen. That should be, put into consideration. That before Ivan Magomo is an athlete, he's a Ugandan citizen and is entitled to enjoy all the rights as enshrined under the Constitution of Uganda. The National Sports Act is a legislative framework that is supposed to regulate sports and govern sports in our country. However, we need to ask ourselves one fundamental question. Does this act and the broader sports sector truly reflect the aspirations, heritage, and autonomy of the Uganda society, or does it bear the lingering imprints of colonial influence and hangover that continue to shape its structure, priorities, and accessibility? Article 2 provides for the supremacy of the Constitution, and within the Constitution we have the national objectives and directive principles of state policy. Under objective objective 17, forgive me, I have a bit of a cold, so yeah, a bit struggling here. So under objective 17, it provides for promotion of recreation and sports for all citizens in Uganda. Objective 26 provides for accountability of all people in places of leadership, because these offices are being held in trust of the people of Uganda. And objective 29 provides for the duties of a good citizen who is supposed to enjoy and exercise their rights of freedom, which are inseparable from performance of duties and obligations, as they are supposed to be patriotic, loyal, do gainful work to help build the nation. Athlete rights are human rights. These have been declared all over the world under the UN Declaration, Human Rights, and under our Constitution. So when it comes to athlete rights, most of the administrators don't really understand that we athletes actually need to enjoy the fruits of our hard work and labor. We are still a bit hangover of the colonial system that needs to be done away with, and we see to it that we manage to do these things, we as Ugandans, and set precedent. We as athletes face a lot of, we face a lot of issues when it comes to our rights, and these issues range from a couple of, laws that have been passed that are only beneficial to the governing bodies and the commercial partners, and actually forget the athletes who put in the work. So on a brief background, those are athlete rights. Every athlete in Uganda is supposed to enjoy their rights as enshrined under the Constitution of Uganda.
Thank you, Ivan. As we wind up, let's make this more engaging. You've talked about rights. In your view as an athlete, do you think the National Sports Act addresses rightly and extensively the rights of athletes, or it's a one-sided law and it's lacking in some aspect as far as rights of athletes? Is it more to do with structures, governance, or as an athlete, you're contented that we have the best law as far as protecting and promoting the rights of athletes is concerned?
Thank you very much, Mr. Kajubi. The National Sports Act, I don't believe gives us much room as athletes to protect our rights. Otherwise, what I can take of it is more aimed at sports administrators and investors' risks. When these administrators, when you have a look at the Sports Act, it provides for economic rights, claiming they belong to the sports federations. The image rights of the athletes belong to the federations, which is wrong. This is a personal, image rights are personal, and as Ivan Magomu, I'm supposed to be able to benefit from my image right. Whether I could give a reference, let me say the Uganda Rugby Union is going to sit on a table with a potential investor. They need athlete representative, an athlete who is well thought and knows about the law, who can be able to go and sit and actually advise on how athletes matters should be handled when it comes to terms of remuneration and all that.
Wow. You've talked about image rights, and I'll use you as an example. Recently, you were involved in an issue relating to your personal image rights with your federation. Many of the athletes may be there, and they are quiet about it. But for you, luckily, you're a lawyer. You chose not to sit on your rights, and decided to take them on. One, share with us, is this issue of image rights reality in the sports industry in as far as athletics are concerned, or it's the same gospel you've shared with us that the federation will dictate, and so for as long as you're a rugby player, you're a basketball player, we own your image, we can use it, and there are contractual arrangements? Or maybe we shouldn't be harsh on these federations. Maybe even the players themselves, they either knowingly or unknowingly license or consent to the usage and commercialization of their rights. From your experience, share with us the reality, such that other sports lawyers and administrators who have their clients, either they'll go back and advise their clients who are federations, and if I'm here, I'm a lawyer, I'll just go back and advise my client who's an athlete to tell them that anytime you see this, ring me, do not sign this contract before I go through it.
Thank you, Mr. Kajubi. The issue of image rights, is it a reality to athletes? I could say yes, but in the long run. Why? Most of our athletes are not well versed with the law. They don't know that the IOC, International Olympic Athletes' Rights and Responsibility Declaration, empowers them to earn off their image rights. So this shouldn't be a matter of discussion when it comes to image rights. The federations, the lawyers of the federations need to come and sit down and have a discussion, if not with the athletes themselves or the athletes' representatives, in this case being the sports lawyers, so that this issue of image rights and athletes' welfare can be handled with ease.
Thank you. Ivan, as we wind up, have you ever appeared before a sports disciplinary committee?
Yes.
Now you are the best person to take us through. You may not have experienced challenges, but if any, what are the challenges you experienced that probably you can share with members here, especially lawyers? They will just go back and either look at those loopholes either to capitalize on them or to advise their clients accordingly. What are those challenges athletes experience or encounter during sports disciplinary hearings from your perspective as a person who has been there recently?
All athletes, first of all, are entitled to a fair hearing. Before, most of the times, athletes go before these panels. It's like the case has already been determined for them. So it is just, going through the process and you await your verdict. Very rarely have athletes come out victorious, unless if they went to the High Court. The challenges that we face as athletes is one, limitation of legal representatives. You go before a panel and they are limiting you on the number of legal representatives you want to avail. It's costly hiring a lawyer, you know that. And then the independence of the panel that's being constituted. You cannot have these very people running the day-to-day activities of the federations or unions being the very people appearing before you on a disciplinary matter. That plays with the legality of you cannot be a boss of your own case. So it interferes with natural justice and a right to fair hearing. That is the biggest issue. Most athletes' cases are determined for them before they even enter the room.
Thank you, Ivan. My last question to you, do these athletes earn salaries? Or when I was still a player, well, I might be donning suits, but I played soccer and we used to use the word muchuba. I remember I was once almost expelled from school for being a muchuba. You can't play for another team or school. Remember at the joint campus, it used to be Coca-Cola post-primary. It's now Coca-Cola for secondary schools, right? Yeah, post-primary. So I'd played in the previous year. Then the subsequent year, of course, done UNEB. I was now at campus. But I was fairly young. I went back to play for my former school. And because of those, they used to be called schools which were in Mukono, they had those discussions. So you'd go and do, I think, those discussions. You'd merge at a certain school. You'd do presentations. So students who were in senior 5 while I was in senior 6, they saw me presenting as a senior 6 candidate. Now I went back, the subsequent year I was at campus. So I went back to play for my former school, still as a player in senior 6. Those who were in senior 5 from other schools who saw me in a certain school where all A-level schools had gathered to do those UNED presentations, they saw me and said, but this man, he has come to play for school X. Last year, he was a senior 6 candidate. They got to me, I told them, well, I failed UNEB. And I told them that the marks I got were not enough. That's why I'm back. Of course, they couldn't trace my university to know that I was a campus. But the point I'm trying to make is that we used to do bichuba, you hired. But also in that arrangement, some of us would take a bottle of soda, they would give you a plate of food. You would play for passion and loyalty. But now things have changed. Is it the same case from your experience that athletes now, because you're not going to thrive only on the passion of the game, you invest your time, especially you're a lawyer, you know how hectic the course is. There's a lot. Do those players survive on plates of food, juice as a consideration? and kind of cheerleading or their structures, to be particular in your sports discipline like rugby? Are there structures from Uganda Rugby Union where they communicate to these clubs, advising them to remunerate the players, or since it's contractual, you either play for free, off a bottle of water, glucose, or you go? So in other words, are they salaried employees? Are they casual employees, or it's for fun?
Thank you. The issue we struggle with as athletes in Uganda is the issue of amateurism. So with amateurism, we find guys playing for leisure, but where we are headed now, like Senior Counsel Alex Luganda mentioned, sports is now a multi-billion-dollar industry, and athletes should be able to benefit from the sweat or the money they contribute in terms of all those deals that go down when it comes to the money bit. Yes, there are some athletes who are contracted. If you look at FUFA, I think it's doing a commendable job when it comes to this. But for the other federations, we need to pick a leaf and go to FUFA and borrow their manual and see to it that these athletes are workers. The ILO Dialogue Forum on Decent Work in the World of Sport recommends governments to make sure that they uphold the ILO standards of labor in their different capacities. And the union is starting to listen because of the pressure, but the contracts have been mostly, promises that never come to pass. And when you speak about the contracts, they don't want to listen to you. So I think we need to really advise the federations as sports lawyers that the matter of contract and contract law, you cannot escape from it when it comes to sports law. There's also the matter of labor law that you can't escape. You mentioned tort. How do athletes safeguard themselves right now? I think we need to be organized and come together as athletes. I see FUFA has a Uganda FUFA Players, I think, Association. Other federations should, pick a leaf and do the same. And then also, they need to be able to organize themselves so they can collectively bargain as athletes. So their working conditions can be improved, their contracts, and everything.
Thank you, Ivan. You, as a rugby player, you're exposed to severe damage, head injuries. You're familiar with the sport injury called concussion. Are you insured in the first place, either on your personal insurance or under club arrangement? And if so, is it the same with other sports players? Because from there, the sports lawyer on this call will now see the gray area and either engage the federation. That gray area is both legal and business oriented. I can engage insurance companies. I think FUFA was trying to moot for that. I may not recall vividly, but I wanted to moot an arrangement of insurance for all players and FUFA. But anyway, from your experience, do you have a policy? If not, what's the problem? How do you safeguard? Because rugby, it is prone, you guys are prone to those concussions. Briefly, then as we wind up.
Thank you. The issue of insurance is a myth in rugby. They only speak about it, but they never come to implement. I have examples of players. I know a few colleagues who have gotten injured, and of course Harambe's run around, and after that the federations forget about the individual, and for them life moves on. This is all about player welfare, and like you mentioned, to the young lawyers or those who want to venture into sports law, these are gray areas. They already mentioned that it's a multi-billion-dollar company, and with a multi-billion-dollar company, there's bound to be issues. This is a green area for the young lawyers who want to take part. There's so much you can do when it comes to practicability of sports law and engaging it business-wise and in other aspects. So I think rugby being a high-contact sport, we need to be insured as athletes, not only in rugby, but all over, because this is my work. Just like you guys got office and are paid and insured, so should the athlete themselves. We need to be very assertive on this. And yes, the lawyers of the various federations need to put a right foot on this and advise the federations that this person needs to be insured so they can give their best for the country and for the interest of the sport. Thank you.
Thank you. I think in the same spirit you've made your closing remarks, especially on the role of sports lawyers or young lawyers on this call. Ladies and gentlemen, we've come to the end of our call. However, kindly display Isaac Luganda's response on stadium naming rights. Try to scroll up. I read it to the down. Isaac Luganda, the one on Hima Cement. Then slightly up. Yes, the reference Alex Luganda responded. The reference to St. Mary's Stadium as Hima must have been a media misrepresentation. Hima Cement sponsorship contract with Vipers was in respect to a different set of club products and commercial rights. Well guided. Thank you so much, Alex. Dennis, are you there? I want to end with you on the issue of salaries. Dennis, are you there? Dennis Lukambi, we want to know players on the national team, are they employees? Do they earn a salary? Or are they contracted, or it's a national obligation? You just come for the pride and patriotism of Uganda, come and play. Dennis, are you there? Such that it's an extension of the rights of athletes. Dennis, if you are unable to speak, you may type your response. I wanted to get it specified from your side. I don't know whether Alex or any other panelist is able to answer that. These players for the national teams, under the National Sports Act, there is a way they are categorized. Yes, they are professionals, but ordinarily it's a course. Anyway, without wasting time, I think we shall end here. I want to thank everyone. There are questions. Let's open the Q&A. Questions. Emmanuel asked how disability inclusion addressed
Hello?
by... Yes.
Hello? Oh yes, Council Uganda here.
Yes, Alex. Can you give it a shot on the remuneration or the status or the category of rights that accrue to players on national team? From where you're familiar with national teams, they vary. Could be basketball, netball, football. From your experience, do these footballers on national team, is it a national call duty or they are remunerated as employees?
Thank you very much. Maybe to answer the same, we need to get the context of for how long do you have, for example, football players participating on the national team? So there is no, first of all, there is no contract that the players sign with the country as far as participating on the national team is concerned, because their call to the national team is determined by the technical team, the coaches. When the coaches are summoning players to the national team, they are guided by a number of factors, including the level of fitness and availability of the given number and the system that the coach in particular is using. And if you may be following, which you are, you sometimes you discover there's someone like 50 players to the national team. The coach informs the federation that we shall need ABCD players. In each position on the pitch, they may summon six players. And the camp initially may have close to 60 players in camp as they are preparing for a given competition. And by the end of the day, the team has reduced to about 25 people. So those that make it finally to the national team get an allowance for purposes of their participation, because remember, they already have running contracts with their different clubs, with their respective clubs. So when they come to the national team, apart from the national duty, the pride, and the fact that even when you get an opportunity to play in the national team, you can easily be marketed and bought by better clubs because of your exhibition and the number of caps you hold as a person. So to briefly answer the same, there is no salary within the context of employer-employee relationship. They are simply given allowances because
Alex,
you can't be sure even whether you'll be summoned for the next appearance.
Alex, before you go off, in the who shoulders the burden of player? Let me not call it welfare, but injuries. If I'm injured at the national team, national rugby team, basketball team, or Uganda Cranes, but I have my contract with my indigenous club where I play from, I get injured at the national team. Is there a tripartite arrangement between individual players, the national federation, and clubs, where they share or shoulder the burden of players' injuries, or it's a question of insurance, which I'm aware it's also negotiated. If it's negotiated at the club level, that's if a player's club has insurance, the insurance company will tell you the limit of their exposure. If it's the club, rather national level. So in that regard, who meets the cost of treating the injury sustained by a player at the national level while they're playing at the national level? Or we go back to the club level to meet that? Thank you.
Thank you very much. And I think if Dennis is able to come through, he should be giving us the current status, because I know the Federation right now has an arrangement with an insurance company where the players that are summoned for national duty are able to get insurance. However, as far as having a clear regulatory legal regime is concerned, I am not yet sure whether we have anything written down like a policy or a tripartite agreement between the football clubs that release the players and the national team. Because remember, sometimes we have players of an international dimension. For example, in Uganda, we are summoning players. We have them from all different leagues and around the world who are Ugandans but participating in those leagues. And initially, by then, when we would have challenges of injury that has been occasioned to a player on national duty, as clubs who are footing those bills. But I think the situation now has changed. Dennis, if he's online, must speak. giving some update on that.
All right. Dennis, are you there? We close with you. Thank you. Thank you. You've come at the right time. In just 1 minute. Thank you.
That issue of players, yes, normally national federations, I speak for football, where I am very well conversant. We have the player status and transfer of players. That is a FIFA regulation for international arena. They specifically said that when a player gets an injury on the national team, the club is responsible for the treatment. Only that we have players in different categories, like national team. Sometimes we invite amateur players that are not under contract. Then the federation will take care of it. But in principle, the federation is taking the burden of ensuring and treating the players. But the obligation, as far as the regulations are concerned, is for the clubs, especially those that are from the international. I mean, when we invite from the international, from clubs abroad, normally they prefer their treatment. So the club entirely prefers to treat the player and take the therapy than the national team. Because national team don't own players. They come and play for 1 day and then they go back to their clubs. That was basically brought in to maintain the consistency. Because if a player comes to Uganda from a club in Egypt, he's only given 5 days. Whether he's injured or not, only 5 days, he has to go back, whether he's sick or whether he's okay. So that's why they leave the burden to the club. But federation always contributes to that for the benefit of not giving the burden to the clubs.
Thank you. I think Alex answered the question I had for you on the status of players on the national team. Even your last comment, I don't know whether I'm correct. That means that they are non-salaried employees. It's in form of allowance. Is that correct?
Yeah, they are not employees, fiscal allowances.
All right. Thank you so much, Dennis, Alex, Dave, Dr. Don Rukare, Ivan, Marcella, and everyone. So let's conclude with the Q&A, then we close it. Emmanuel asked how disability inclusion addressed by the laws. I would gladly appreciate how to participate in the process. I have not heard anything mentioned in this regard. How is commercialized and marketed for persons with disabilities? That's an interesting question. Dr. Don, Emmanuel Chandia, thank you so much. You raise, I think it's the something Dr. Don raised, that the National Sports Act seems not to cater extensively, if it does in any case, for PWDs, and also as far as commercialization is concerned. You're offering to guide whoever is in the policy making mechanisms to ensure that this is catered for. Surely, I'll get in touch with Don. I'm sure you must be having his contact. We're happy to have you as a ULS cluster to contribute to this. Rebecca Nasuna, if I'm contacted by an existing academy to provide advice generally, where do I start from as a lawyer? Do I have to look at compliance with the laws only, or there are other areas I have to engage them on? Marcella, that's your question. Marcella?
Thank you.
Yes, Marcella.
I was actually in the process of typing and then the system locked me out. I wanted to tell her that usually, depending on the sport you're under, each federation has its own regulations. So it being association, you need to know what are the regulations of the federation you're associating with. For example, for football, you have FUFA, and then you also have UIFA. If it's an academy that plays football, you need to register with UIFA, and then you also...
Thank you, Patience. I hope
so it depends.
Yes, thank you, Patience. Let's
I
see
want
the
to
next.
say something very briefly.
Yes, Alex, in a few minutes because we are out of time.
Yeah, I just want to encourage the members of the legal profession and the young lawyers that sports is very rich with a lot of legal regimes. So you get down on the internet, most of the sports that are internationally regulated have all the relevant laws and regulations on the websites. So it is very important that you first of all interest yourself in appreciating those particular laws, depending on which game you want to support, but also at the same time, it has a cross-cutting effect on multi-sectoral legal regimes. So you have to interest yourself, but also to thank you, Brian, that we need to do more of these trainings and have more time on specific topics such that we exhaust them to give the members an opportunity to appreciate one at a go. But this has been a very good start, and we have a lot of work in progress. Our contacts are available such that in case any of the lawyers interested in joining, both young lawyers but also senior lawyers who are interested in following up in sports law, we can link up on a one-on-one, and we have some notes shared for purposes of enhancing our capacity. Thank you.
Thank you. Maybe to the lawyers and administrators on this call, I'll start with, I think he has left, Dennis, and the rest. You see, one hindrance to the growth of the sports sector, it might be doing well in other fields, but like you've said, sports law is wide. There's a component of tax law in sports. Previously, I was having a discussion with Dr. Mulindra, the proprietor of Vipers and St. Mary's, and I think, Alex, you are very familiar with this. His concern would tell you that importing these sports equipments to establish a very good and robust sports facility is quite expensive. Uganda, we are hosting CHAN very soon. We need as many sports facilities as possible, but a few people who can afford to bring them, still they're telling you to bring those equipments, not only even proprietors, but even sports persons, the athletes, the clubs. They want to buy genuine stuff, but they will tell you the taxes. Maybe Mr. Dennis, I'm sure he has, I don't know if they're still on the call. Just this is a message. You can engage the federation president with other federation heads. I don't know whether in Uganda, other than the National Council for Sports, but do we have a private federation umbrella where heads of federations sit down and share challenges, experiences, and have a uniform position? But my request, I've engaged different proprietors and sports persons. They'll tell you that sports equipments, genuine ones that are manufactured abroad, they're quite expensive. So for those that are manufactured from here, and as a gift to Uganda, in lieu of hosting the forthcoming Uganda African Cup of Nations, different stakeholders, you may lobby probably in the next financial year, Minister of Finance waives or gives waivers on some of these sports facilities or equipments rather, to enable the growth of the sports sector. For me, that is what I would want to share with you. You collaborate with other sports able-muscled persons, administrators, federation presidents. At least it's something small. Let them have a wave of or tax incentives for 1 year, such that they hope those who have built stadiums, those who own sports facilities, to build them and empower and establish a proper infrastructure. Anyway, let's conclude with our questions in the chat. Members have patiently waited. Andrew Allah, thank you panelists for your great insights on today's theme, but was wondering whether there are regulations already enacted under the National Sports Act and which ones in particular this could have skipped. I'll briefly answer that. Yes, Andrew, there are draft regulations. They are still in draft process, but very soon they will be presented, and personally I've written about lack of them in the newspapers, but hopefully with time we shall have them ready. Any other? I think that's all for the questions. We can go back to. So, members, ladies and gentlemen, thank you so much for being this patient from 8:30 a.m. up to almost 1:30. I want to thank the leadership of the Radical Nuba Uganda Law Society. Thank you for organizing this. Sports Law, CLE. Maybe sports lawyers on the call as you're preparing to leave. I'll task the leadership at Uganda Law Society in the next sports law CLE training, that is next year. We should now concentrate on two things. One, player welfare. I think so many CLE trainings we've had, it's been about how lawyers benefit or how other stakeholders. A topic like commercialization, as much as an athlete may also commercialize, but they don't have much to commercialize other than deal endorsements and I think image rights. Those are the few. But at the end of the day, the fan or the consumer, the sports administrator, the regulator, the federation, the club, they are the ones who benefit. In fact, all of us, we are here, we're having this discussion because of the Magomos, all those players. So wouldn't be having this law if the players. So those are the most important persons. So if we only think about ourselves, other relevant stakeholders, the sponsors, and we don't think about the welfare of these people who are the reason why we benefit from them, I think we need to first empower them. We can borrow relief from other international sports federations, rather not international, other federations. So empower, put a professional structure. Thanks to the Act, it has now tried to streamline professional sport from amateur. So to the powers that be and any other stakeholder, please let's prioritize the rights and the plight of sports persons or athletes before now we overhammer the point of how does a lawyer benefit from in that. Well, that's my opinion. If a player is not well on the pitch, is an MVP, me as a sports agent, a sports lawyer, a brand related lawyer, I will not eat from that brand. But it will be me to blame or the regulator or the club. No insurance, other people in other jurisdictions, you find a player has two policies. His head is insured and the legs. So the arrangement is if I sustain an injury, a head injury, depending on the terms or the clauses of my policy, then if every time I'm on the pitch, just being named in the club, even if I'm not on the pitch, but I'm in the lineup of, let's say, 15 players that are traveling to Hoima to face Chitara. Just being mentioned, I have a bonus. Let's say a bonus of 500,000 shillings. Then if I enter on the pitch, those are terms that are negotiated by what the Act calls promoters and agents. So I negotiate a clause that whenever my player appears on the football pitch, that's another 500,000 shillings. So far you have 1M. Next, if the team wins, that is 1M. So you have your 2M. Next, is my player or my client scores a goal, this amount of money. Now, in addition to the salary, let's assume that these players don't have salaries. Okay? Those bonuses, those negotiated clauses, they will motivate them. Now, even me, the lawyer, and the fan, the other side, I will see a player, we call it Kuyua Umubiri. You know, the player is so much dedicated, committed to the game because he doesn't even see the salary as the most important thing. He's looking at these bonuses, how they were well negotiated by his or her lawyer. But if we're only going to wait for disputes alone, they may not come, and we shouldn't blame these athletes. They'll say, why am I going to hire a lawyer when I don't even have that money? So my humble request to all of us on this call, in the next session, whoever will moderate or will be in charge of crafting topics, let's utilize like 2 or 3 related CLEs on player welfare and raise things of concussions. They're very, very important. Then the rest we can discuss how we commercialize the game of sport. Thanks so much, the Committee of Legal Education and Training of Law Council, for approving such trainings for sports law. Special thanks to the panelists who reach out to you on short notice. Alex, Dave, Don, Patience, Dennis, I hope I've not left out Ivan. Thanks so much. Then lastly, I want to thank the panel, the attendees on the call. You've been patient. And above all, I want to thank the partners at Max Advocates, the conveners of this CLE that have accorded us tremendous support in ensuring that we have a successful CLE event. You've earned yourselves your 5 CLE points. ULS CLE team will communicate in due course. Thank you so much. May we do our best to ensure that this industry really develops, not only to the benefit of sports lawyers, sports administrators, but most importantly, to the best or to the benefit of the athletes, who are the reason as to why we always flood and flock those stadiums, and in long run, all other brand sponsors will benefit. May the good Lord bless you. See you, I think, on 17th for the GSC or the AGM activities. Thank you so much. We'll close our session. All the best and a lovely weekend.